President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Nigel de Freitas, who is out of the country, and to Senator Khadija Amin, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Mr. Ndale Young. Whereas Senator Nigel de Freitas is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula Mae Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 4th of December 2018 and continuing during the absence from Trinidad and Tobago of the said Senator Nigel de Freitas, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of December 2018. To Mr. Brian Nathaniel Bigg. Whereas Senator Khadija Amin is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Brian Nathaniel Bigg, to be temporarily a member of the Senate with effect from the 4th of December 2018 and continuing during the absence of Senator Khadija Amin by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of December 2018. Honorable Senators, Senators are required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Brian Bigg, having been appointed a Member of Parliament, do swear by Almighty God
that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives. The Income Tax Amendment Bill 2018 in the name of the Attorney General.
Attorney General.
Madam President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the bill be taken later in the proceedings. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken later in the proceedings.
Petitions, papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The annual audited financial statements of the National Maintenance, Training and Security Company Limited for the year ended December 31st, 2017. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper in the name of the Minister of Housing and Urban Development, the Attorney General, the Minister of Education and the Vice President. The Trinidad and Tobago Housing Development Corporation vesting amendment to the first schedule number 3 order 2018. The ministerial response of the Ministry of the Attorney General and Legal Affairs to the 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session, 2017-2018, 8th Parliament on the examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. The ministerial response of the Ministry of Education to the 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session, 2017-2018, 8th Parliament on an examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. The response of the Personnel Department to the 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session, 2017-2018, 11th Parliament on an examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services.
Urgent question.
Senator Hussain.
Very much, Madam President. To the Minister of Public Utilities, in light of yesterday's announcement that there has been an emergency shutdown of the Point Lisas desalination plant, can the Minister indicate when the plant will again be operational?
Minister of Public Utilities, you have 2 minutes.
Madam Speaker, there was a disruption in the operations at Point Lisas desalination plant, which occurred about 10 a.m. yesterday, Monday, the 3rd of December, as a result of some electrical problems. The desalination staff are addressing the issue. Repairs work is actually ongoing. The desalination plant will start delivering water to Wassa, 10 million gallons a day by 2 p.m. today, with a further increase to about 20 million gallons a day by about 11 p.m. tonight. The schedule is expected to ramp up to full capacity by about 10 p.m. tomorrow.
Next question, Senator Mark.
Thank you very much, Madam President. To the Honourable Minister of Rural Development and Local Government. Given the recent fire at the Drag Mall in Port of Spain, which has adversely affected the livelihood of scores of persons, what steps are being taken by the government to assist these small business owners?
Minister of Rural Development and Local Government, you have 2 minutes.
Thank you very much, Madam President, and I would like to thank Senator Mark for the question. This is the second fire for this year held at the People's Mall, or the Drag Mall, as it is referred to here. And this is the third time that this mall has been burnt in recent years. Following the first fire this year, the Port of Spain City Corporation approached the People's Mall Management Company Limited, who managed the space, and asked them not to rebuild unless a clear plan for the layout was submitted, as they were not using fire-safe practices or building materials. Following the most recent fire, the Port of Spain City Corporation again met with the mall management, which was in agreement that for the long term, they would submit a booth and a layout proposal to ensure the safety of the vendors, patrons, and neighbors of the space. It was suggested by the corporation that in the interim, the vendors set up tents in the parking lot of the mall in order to continue their Christmas sales with minimal interruption, while the long-term plans are decided. However, individual vendors have come forward to say that the mall management is not an appropriate representative of their interests. Therefore, at this time, the Port of Spain City Corporation is bringing all parties together for a dialogue on the safetiness and most coordinated way forward in the best interest of all stakeholders. Meetings were held earlier this week, and there's a follow-up meeting planned for this coming Monday. Thank you very much, Madam President.
Senator Mark.
Madam President, in light of the fact that the government has indicated that the vendors would be allowed to conduct some trade on the compound of the burnt-out mall, could the minister share with us whether the government intends to allow vendors to vend on Charlotte Street?
No, that question does not flow from the answer that was given. Senator Mark, next supplementary question.
May I ask whether the minister, through you, is in support of the Mayor of Port of Spain's position not to allow vending on the streets of Port of Spain, inclusive of Charlotte Street?
That doesn't arise either to the question posed, Senator Mark. Next question, Senator Mark.
To the Minister of Energy and Energy Industries, in light of claims made by several former Petrotrin workers that they have not yet received their severance payments, can the minister indicate what steps are being taken to address this issue?
Minister of Energy and Energy Industries, you have 2 minutes, please.
Thank you, Madam President. Madam President, as I speak, all workers on the Petrotrin payroll have been paid, including the 1,129 non-permanent workers who qualified for ex gratia payment.
Senator Mark.
Madam President, through you, can the minister inform the Senate whether the severance formula as outlined by the Prime Minister to increase from 300,000 to 500,000 is being met in this particular regard?
Minister.
Madam President, that matter will be addressed shortly by the Minister in the Ministry of Finance, but Cabinet did in fact approve the 500,000 limit to be tax-free, and that will be effected later on because the taxes was placed in an escrow account on behalf of the employees, and they have to get their clearance from the BIR.
Senator Mark.
Madam President, do I go to the next question or can I ask a supplemental?
You have one more supplementary.
Madam President, through you to the Honourable Minister. Honourable Minister, can you advise the Senate whether legislative changes would be required to the Income Tax Act to give effect to the severance packages, given the increase from 300,000 to 500,000?
Minister?
I'm not quite certain, but that matter will be addressed later on by the Minister in the Ministry of Finance.
Next question.
To the Honourable Minister of Public Utilities, having regard to the emergency shutdown of the desal cut plant and the disruption in the water supply to residents in south and central Trinidad, can the Minister indicate whether any mitigating measures have been put in place?
Minister of Public Utilities.
Madam Speaker, some of the affected areas for note is Caroni, St. Helena, Charleville, Shagwana, Skunupier, Karipichaima, all the way to Faizabad, San Francisco, Coquille. In order to mitigate the effects of these supply shortfalls on operations, the authority will be redistributing supplies from Caroni and the Navet water treatment plants, as well as the implementation of temporary supply schedules. This will be supplemented by the supply of truck-borne water services, and so far 50,000 gallons of water via truck-borne water supply services have already been delivered. The public have been advised of this situation and request to conserve water. Public notices have also been put out.
Senator Mark.
Next question,
Senator Mark, next question.
To the Honourable Minister of Finance, can the Minister indicate what, if any, additional support has been put in place at the Board of Inland Revenue to expedite the processing of BIR documents of former Petrotrin workers?
Minister in the Ministry of Finance, you have 2 minutes.
Thank you, Madam President. Madam President, the Board of Inland Revenue has redirected additional resources. I've been advised it's 10 in number to address the additional responsibility brought about by the Petrotrin exercise. And these employees, including the ones who are permanently assigned to this position, have been working weekends and overtime to get the exercise completed. Thank you, Madam President.
Senator Mark.
Can I ask the Honourable Minister whether legislative changes to the Income Tax Act would be required to give effect to the severance payment that the workers have been promised, increasing from 300,000 to 500,000?
Minister. Yes, Madam President. As Senator Khan would have indicated, Cabinet has approved this adjustment, and yes, legislative amendments will be required to give effect to it, and those legislative amendments will be brought before Parliament shortly. In the Finance Act. In the Finance Act. This month.
Madam President, through you, in those circumstances, the workers will not be paid in accordance with the particular formula as outlined by the Prime Minister until legislative approval would be granted or would have been granted by the both houses of Parliament. Can I see clarification?
Minister.
There are a couple of issues which the Board of Inland Revenue is dealing with in terms of how much tax is to be accounted for in respect of each payment. This is what is taking a while. One of the issues is whether the payment qualifies for exemption at all, and if so, how much. So what the company has done was paid the individuals the amount net of estimated taxes, and adjustments will be made as they get signed off from the board as to how much tax is actually due.
Questions on notice, questions for oral answer.
Leader of Government Business.
Madam President, the government is pleased to announce that we will be answering all questions. And on written questions, we ask for a deferral of question number 49 for 2 weeks.
Senator Ramdeen.
Good afternoon, Madam President. Thank you very much. Question number 9 to the Attorney General, Madam President.
Attorney General.
Madam President, I thank Senator Ramdeen for the question. I'm informed by the judiciary of the Republic of Trinidad and Tobago that the average time taken to file an indictment in a capital matter from the time that the proceedings were received by the Magistrates Court to the time that the indictment was filed in the High Court is approximately 6 years and 2 months. And with respect to the capital matters, I can confirm that that is with respect to murder only, as there were none with respect to treason.
Senator Ramdeen.
Thank you, Madam President. Thank you, Attorney General. Madam President, to the Attorney General, through you. Attorney General, what steps are immediately being taken to address this very prolonged period of 6 years plus to treat with persons who are not entitled to bail and remain incarcerated during this period of time while their indictment has to be filed in the High Court?
Attorney General.
Much obliged. Thank you again, Senator Ramdeen, for a very important supplemental question. I'm very pleased to say that the steps include a number of measures: legislative, operational, and then management. On the legislative side, this Parliament has, of course, contributed to the development of that by the establishment of criminal proceedings rules, by the proclamation, in fact, on the 1st of December of a criminal division, by the divisioning out and the introduction of other areas of the court, including the family division, the traffic division, by the implementation of new courts, by the increase in the judicial complement of almost 77% from where we first entered. On the practical side, by the implementation of a computerized system in the magistracy, and as is now, without breaching the rule of anticipation, as is laid in the House of Representatives, by the abolition of preliminary inquiries. So there's a managerial side to quicken the pace. There's a provision of resources to quicken that pace, which does also include improvements in the Director of Public Prosecutions, physical accommodation, manpower accommodation, and their capacity of managerial input being improved by the use of computerized systems. So there's quite a lot going on.
Senator Ramdeen.
Madam President, thank you very much. To the Honourable Attorney General, through you, Madam President. Attorney General, in most of these cases, the extended period of time is a result of the lack of staffing in what we call the out courts, like Mayaro and Rio Claro and Arima. Is any specific attention being given to those particular courts so that the persons who are committed for a capital matter in those courts can also have some kind of equality of justice in these kinds of matters to have their matters heard?
Attorney General.
Thank the Honourable Senator again for a very important question. The answer is quite simply yes. It was the creation of the divisioning of the criminal division and traffic courts that really facilitates that, specifically with the operationalization of Section 24 of the criminal division, which allows the Chief Justice to create specialist courts. The administration of justice as a whole in the judicial complements and staffing and managerial positions has also been materially managed. I will point honourable members of the Senate to the fact that we are replacing, as of February the 1st, the entire managerial structure of the magistracy by removing the clerks of the peace and introducing registrars for the first time. And the harmonization between the jurisdiction of the High Court and the Magistrates Court also goes to a significant improvement, because we will now have masters of court treating with the management of the caseload itself. So there's been a well thought out plan which is in the course of implementation. A lot of it has actually happened. The laws have been proclaimed, the staff has been hired, and with respect to plant and machinery, that aspect too is also the subject of significant development, including, as the Minister of National Security takes that charge, the development of specialist courts in other arenas, including the prisons. That is, physical courts inside the prisons to treat with the caseload flow and management.
Ramdeen.
Thank you. To the Honourable Attorney General, through you, Madam President. Attorney General, being the Minister in the Cabinet responsible for legal affairs, has the Office of the Attorney General received suggestions from the Office of the Director of Public Prosecution, who is responsible for the filing of these indictments, as to how the process can be speeded up at that end of the yardstick?
Attorney General.
Yes, Madam President. Yes, in fact, we have. Some of the suggestions received from the DPP included the request for caseload software and management, the provision of case progression officers, the training behind the criminal proceedings rules, the requirement for new positions at the DPP's office to work alongside with the magistrate side of it, and on the magisterial side of it, and on the High Court or judiciary side of it, obviously the equal management of the case progression through masters of court and other positions. Madam President, it's material to note that with the anticipated abolition of preliminary inquiries, that in the case management structure itself, there will be a rapid improvement in the structures because of the use of the masters of court to engage in sufficiency hearings and initial hearings as well.
Next question, Senator Ramdeen.
Thank you, Madam President. Question number 11 to the Honorable Attorney General.
Attorney General.
Thank you, Madam President. Madam President, during the period September 2015 to September 2018, no persons have had their death sentences commuted pursuant to the Privy Council's decision in Pratt and Morgan.
Thank you, Madam President. Madam President, to the Honorable Attorney General, could the Attorney General inform the Senate as to the reason why persons who would have expired the 3.5-year and 5-year period specified in Pratt have not been commuted during this period, September 2015 to September 2018?
No, I won't allow that question as asked because you're making certain assumptions in your question. So you can ask another supplementary question.
Thank you, Madam President, I'm guided. Can the Attorney General tell us how many persons would have expired the 5-year period specified in Pratt during this period of time?
Attorney General.
Regrettably, I can't answer the question as last asked, but I could have answered the question as you've guided otherwise.
Yes.
So I don't know how I can...
No, well, if you can't answer it, next question, Senator Ramdeen.
Attorney General, do you accept that it is a very unsatisfactory position for persons who have expired the prohibitory period in Pratt and Morgan to remain on death row in breach of their fundamental rights as specified by Judicial Committee?
Senator Ramdeen, I won't allow that question. Shall we move on, Senator Ramdeen, to your next question? Thank you.
12 to the Honorable Attorney General.
Attorney General.
Madam President, I'm able to answer question 12 as follows. The total amount of monies paid provided to the Office of the DPP in respect of this matter for the period stated above, and that is, Madam Speaker, in respect of the CLICO matter, monies provided for the period September 2015 to September 2018. The total amount of money provided is $125,688,798,000. I note, however, Madam Speaker, that this sum is in fact a sum which will go upwards because there is inclusion of 2 sets of further fees for that period that the office was not able to compute in time. So the figure is above that.
Senator Ramdeen.
I'm obliged, Madam President. Thank you very much. To the Honorable Attorney General. Attorney General, without asking you to specify with the specificity that you gave in relation to the answer that you gave, in this particular investigation is now going into 3 administrations. Can you assist the Senate in any way in telling us over these 3 administrations what is the average period, what is the average amount of money that has been provided to the Office of the Director of Public Prosecution in this matter?
No, Senator Ramdeen, that question doesn't arise from either your question posed or the question answered.
Thank you,
Next
Madam
question.
President. Attorney General, I'm just inquiring, Madam President, did the Attorney General answer question part 2 of the question?
Attorney General.
I sincerely apologize. The numbers tripped me, and Senator Ramdeen is correct. Madam Speaker, no persons have had criminal charges preferred against them arising out of these matters.
Senator Ramdeen.
From the information, thank you, Madam President. Honorable Attorney General, from the information provided to you as Attorney General in charge of legal affairs, can you inform the Senate as to how long it is expected that these investigations are going to continue?
Attorney General.
Madam Speaker, Madam President, the data which I have demonstrates that certainly investigations into the CLICO matter have been proceeding in this realm, that is the DPP's realm, in the period 2013 to today's date. And whilst it's true to say that the figures currently reflect approximately $180 million in expenditure for fees at the DPP's office for that period, the time frame specifically for the conclusion of the investigation is one which rests exclusively with the office of the DPP. I have been informed, and I verily believe, that the office is close to its conclusion. That is the information which has been provided to me. Of course, I am precluded by virtue of the Constitution and Section 90 in particular from having any form of direct inquiry into this matter. Suffice it to say that the government trusts that the DPP is moving with alacrity and sincerity as he always does.
Next question, Senator Mark.
Thank you, Madam President. Question number 26 to the Minister of Finance.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, the National Insurance Board of Trinidad and Tobago invested $585,691,000 in the National Investment Fund. The investment was allocated as follows. Series B, the 7.5% fixed rate bonds that are due to mature in 2030. They invested $397,756,000. And in Series B, the 6.6% fixed rate interest bond due to mature in 2038, the fund invested $187,935,000. The board considered the following factors before investing in the NIF. NIF bonds are listed and traded on the Trinidad and Tobago Stock Exchange, and ownership of these bonds will improve the liquidity profile of the National Insurance Board's portfolio. Participation in the NIF would allow the National Insurance Board to replace its maturing investments, which are currently yielding 4.78%, with instruments that have higher rates of return of 5.7% and 6.6%. There are limited suitable local fixed income securities, and the NIF bond tenors of 12 years at the rate of 5.7% and 20 years at the rate of 6.6% were attractive. The NIF bonds are rated investment grade and as such qualify for the National Insurance Board investment portfolio. And finally, the last issue considered in determining the investment, the ability of the NIF Holding Company Limited to service its debt obligation is expected to remain strong and resilient. Madam President, the challenges facing the National Insurance Board are structural in nature, such as the aging national population and the shrinking contributory base, and are not negatively impacted whatsoever by the investment in the NIF. In contrast, investment in the NIF bonds by the NIB will result in higher returns, which will be used to grow its own fund to pay benefits to all participants in the system. The NIB is able at this time to maintain a buffer of liquid investments to meet benefit payment needs. This buffer was maintained following the NIF board's investment in the NIF. So beneficiaries of the NIF have no immediate concern in respect of that investment. The board's investment in NIF has complied with all legal requirements. I thank you, Madam President.
Senator Mark.
Madam President, can the Minister advise this Honourable House, Senate, which body or unit within the NIB took the decision to invest over $585 million in this particular scheme? Could you share with the Senate which body within the NIB took that decision?
Minister.
Madam President, I don't have those specific details. I would assume that it would be the investment unit advising the board of the NIB.
In light of the fact that we have been advised that one of the challenges is structural in nature, dealing with the aging population. Can the Honourable Minister indicate whether there are plans by the government to increase the retirement age for persons who are members of the NIB scheme?
Senator Mark, that question does not arise. Next question.
I'll go.
Yeah? Okay. Next question, Senator Mark.
Question number 27 to the Honourable Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, at this time, I would like to again express my deepest condolences to the family and friends of 9-year-old Emmanuel John. In these moments of loss, words are sometimes useless. But please note that our prayers and good wishes of peace and comfort are with you. Madam President, the Traffic Management Branch has two types of pedestrian crossing programs, the zebra crossing and the accessible pedestrian signal. These are the ones that are used outside the Parliament building for the visually impaired and other users. In accordance with the program mentioned above, in this fiscal year, the TMB will be installing 9 new zebra crossings and 15 new accessible pedestrian signals. Madam President, these new installations will be implemented throughout the country, some of which will be on the priority bus route. Additionally, in the last fiscal year, 15 normal pedestrian signs were replaced by the ASPs. In this fiscal year, the Traffic Management Branch will be installing throughout the country these 15 normal signs in locations where they are non-existent at this time. I thank you.
Senator Mark.
Madam President, can I ask the Honourable Minister whether steps are being taken to increase the level of surveillance by his ministry in conjunction with the police, transit police, to have greater surveillance on the priority bus route. Can you tell us if any action is planned in that regard?
Minister.
Madam President, yes, the ministry have been in touch with the transit police, and there have been a stepping up of the activities on the priority bus route. Thank you.
Senator Ramdeen.
Thank you, Madam President. To the Honourable Minister of Works and Transport. Honourable Minister, have you been in communication with the Trinidad and Tobago Police Service to ensure that the areas on the priority bus route where these accidents are likely to occur, the popular area, can have the kind of monitoring that we have down at Freeport, that is engaged on a daily basis by the highway?
Minister.
Madam President, I don't know what the Honourable Senator is referring to, the normal on the Butler Highway. But what I can say is that the priority bus route is policed by the transit police on a regular basis. And unfortunately, when accidents like these occur, it's unfortunate. But we have been liaising with the police for enhanced patrols on the priority bus route. Thank you.
Senator Mark, next question.
Question number 28 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, the Commissioner of Police has indicated that should a situation arise where an officer refuses to identify himself or herself to a member of the public, and that officer is in uniform and is driving a marked police vehicle, the member of the public is advised to immediately comply with all instructions, noting the time and place the incident occurred, as well as any other pertinent information, such as vehicle number, and as soon as possible report this to the Police Professional Standards Bureau. A complaint may also be made to the Police Complaints Authority. If, however, the person is not in uniform or in a marked police vehicle, the member of public is advised to proceed to the nearest police station and report the incident and obtain a receipt for the report made. Further to the above, the Trinidad and Tobago Police Service has issued tenders and received replies for the supply of badges, gold for the 1st Division and silver for all 2nd Division officers. These badges will contain the officer's name and regimental number, which will be easily identified by members of the public. These badges will be utilized as the TTPS's identification going forward once procured.
Senator Mark.
Could the Honourable Minister indicate what time frame he anticipates for the
procurement
of those badges, gold and silver?
Minister.
Madam President, unfortunately, I don't have that information. That's within the purview of the Trinidad and Tobago Police Service. But the Commissioner has said they have already begun the process, received the replies. So I assume the evaluation is taking place, and then it will be the award of the contract.
Next question, Senator Obika.
Thank you, Madam President. Question number 53 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, the Commissioner of Police has advised that the Trinidad and Tobago Police Service has received a total of 3,044 reports of card skimming over the period January 1st, 2017 to November 15th, 2018, amounting to $27,482,292.22 being skimmed illegally.
Senator Obika.
Thank you very much, Madam President. Could the Honourable Minister inform the Senate how much has been recovered in the interest of the customers?
Minister.
Madam President, I don't have that information.
Next question, Senator Obika.
Thank you very much, Madam President. Question number 54 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, no application has been received from Sunwing Airline Incorporated to operate direct flights between Toronto and Tobago, or Toronto, Tobago, Toronto. It follows, therefore, that no approval could have been given for such. Thank you.
Senator Obika.
Yeah, thank you very much, Madam President. Then could the Honourable Minister indicate if reports that Sunwing is carded to start flying the route at some time in the future, are these reports true or otherwise?
Minister.
Thank you. Madam President, I don't know of any report of any planned trip. However, before any airline can operate within our fly zone, permission must be granted by the Civil Aviation Authority. And as I said before, there have been no application for Toronto, Tobago, Toronto, or Toronto, Tobago before them. Thank you.
Senator Obika.
And then I would like to ask a question, final supplemental on this question to the Honourable Minister, if he's aware that the Canadian Transport Agency is investigating Sunwing Airlines in particular.
That question doesn't arise. Senator Obika. Next question.
Thank you very much, Madam President. Question number 55 to the Minister of Education.
Minister of Education.
Thank you very much, Madam President. The University of the West Indies, UWI, St. Augustine campus, has advised that the campus has not initiated any disciplinary action against the students who were arrested during the protest action on October the 18th, 2018 at the University of the West Indies, St. Augustine campus. The UWI maintains that students' activism is central to university life, and activism underpins much of the current UWI AAA strategic plan. The Code of Principles and Responsibilities for Students at the University of the West Indies St. Augustine campus, August 2018, acknowledged under Appendix C, 13, that, and I quote, obstructing or causing to be obstructed the lawful use of access to or egress from university premises or a part thereof is misconduct, in respect of which a student may appear before a disciplinary committee. However, in light of the circumstances leading to the protest, the intervention of the Trinidad and Tobago Police Service, the consequent arrest of the students, and the legal process that has ensued, the decision was taken by the campus not to apply any internal disciplinary measures. While the protesters transgressed the code of principles and the responsibilities, the subsequent events that unfolded provided a cogent learning opportunity for these future leaders in society and for greater appreciation of the laws of the land. Thank you.
Senator Mark.
Madam President, may I ask the Honourable Minister whether he can share with us information surrounding the agency or personnel involved in seeking the intervention of the police in what was otherwise a very peaceful protest organized by students on the campus.
No, Senator Mark, I won't allow that question.
Okay.
Honourable Senators, may I just say that question 49 has been deferred for 2 weeks.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. I beg to move that a bill entitled An Act to Amend the Income Tax Act be now read a second time. Madam President, my first order of business, recognizing the many faces opposite me now on the bench that is just above the opposition, is, with your permission, to welcome all honourable independent senators who are joining this particular session of the Parliament to the work of the Parliament. I know that you are no strangers to hard work, careful consideration, good humour, and strident debate, and I look forward to receiving warmly your recommendations, listening to your fulminations, and certainly finding a better path towards legislation in Trinidad and Tobago. With that said, off we go to this particular bill in this particular climate for the particular reasons that we are gathered here today. Madam Speaker, Madam President, this bill is not a complicated bill. It's really an actually quite simple piece of law which has had a fairly complicated history in getting here to the Parliament. Madam President, Senator Obika seems to have some eruptions that he wishes to put on the floor. I'll give way.
I was only seeking to correct the speech of the Attorney General. It's not a simple piece of law, but a lazy piece of law.
I thank the Honourable Senator for putting his views onto the record, which I'm sure to address in the wind-up. So, with hopefully that out of the way, the exuberance of my learned colleague, we can return to the serious business at hand. Madam Speaker, Madam President, this bill has come from the House of Representatives, and in its form now before us for debate, stands at a few clauses, barely 5 in number, which effectively propose amendments simply to the Income Tax Act. Madam President, the Income Tax Act is no piece of legislation without serious bite. After all, there is supposed to be a certainty in only death and taxation, depending upon the way that you look at it. The Income Tax Act, Chapter 7501, is some 80 years old. It was first brought into its form, the original form, by Act number 34 of 1938, and it's been amended roughly 109 times now. In particular, the last amendment to the Income Tax Act was done by Act number 4 of 2017, most commonly known as the FATCA law. It was that Tax Information Exchange Act, Act number 4 of 2017, which specifically amended the Income Tax Act in consequential amendments to include a new provision, Section 117A of that law. Now, I say that marking the spot to a point that I will return. So let's get back to this bill. Let me put on record, first of all, in demonstrating its proportionality and purpose, what the aim of the legislation is. This bill is intended to achieve compliance with 3 particular goalposts. The first goalpost is compliance with the methodology and requirements of the Financial Action Task Force. Trinidad and Tobago is a member by virtue of its membership of a sub-body called the Caribbean Financial Action Task Force. We are a member of that larger group of countries comprising 190 states. We have signed on as a jurisdiction since 1989 to observe the United Nations principles in countering terrorist financing and countering money laundering, as it's now associated with anti-corruption measures. The Financial Action Task Force has 40 recommendations and 11 immediate outcomes. And essentially that Financial Action Task Force is a body which comes in by virtue of a methodology called mutual evaluation and review. The countries come together, they take the FATF methodology, they do an on-site examination of your laws, they look to see if you have laws, which they call technical compliance, and then they look to the efficiency of your laws. And they rate you against these particular standards, the 11 immediate outcomes and 40 recommendations, and they come up with a report. Trinidad and Tobago has been through first round mutual evaluation, second round mutual evaluation, third round mutual evaluation, and fourth round mutual evaluation. And our fourth round mutual evaluation for the Financial Action Task Force occurred in January 2015 because we were committed as a country by virtue of the cabinet then sitting to undergo the fourth round mutual evaluation as the first country in the 27-country basin that FATF comprised then to want to undergo this evaluation report. Suffice it to say, we did not do well. We were deemed to be in need of serious amendments to our laws, and the mutual evaluation report was published in June 2016. In June 2016, the outcome of our report was so bad that we were put into 2 levels of scrutiny. On the first hand, we were put into scrutiny under the Financial Action Task Force, under a body which does the scrutiny. It's called the Intergovernmental Cooperation Review Group, the ICRG group. And that ICRG group sits you down over a period of several years, 3 years in fact, and sets out a plan of action that the country must commit to lift itself out of non-compliance. If you don't make progress in that follow-up reporting cycle, you have the opportunity to be downgraded. And if you do nothing at all, or if you are downgraded, you suffer the consequences of the international community saying to you that you will be treated with enhanced due diligence.
I just wanted to know if that action plan, that 3 years action plan, can be made available to us also.
Sure. I invite my honorable colleague to the published mutual evaluation report and to the published post-observation follow-up reports, which are in existence and have been for many years and are available in the public domain. So you have it, Honorable Senator, or you ought to have it, certainly as you've come to the debate today. Because this is not the first bill that we're treating with as law. We have done several of them over the several years here, and this has been a feature of that. So in the progress report, if you don't progress, you fall to be the victim of what they call enhanced due diligence. They apply sanctions to you, and that International Cooperation Review Group says to the whole world, by way of a statement of non-compliance, that the world should not do business with you, that the world should restrict banking, the world should ask for customer due diligence of a deeper kind, or the world should consider not doing business at all. That has resulted in a phenomenon called de-risking or loss of correspondent banking, which I'll come to in a moment. But that's only the ICRG at FATF. The second form of discipline that we were put into is under the Caribbean Financial Action Task Force. That's called a FATF-style regional body, or an FSRB as it's referred to. And in the CFATF world, we were also put into reporting requirements because we were put into what they call enhanced follow-up. So in the FATF world, on the first purpose of this legislation, we were put into two forms of review with jeopardy in two separate pots, the Financial Action Task Force pot and the Caribbean Financial Action Task Force pot. And those two pots meet twice a year each. So there are 4 meetings every year, 2 for the FATF, 2 for the Financial Action Task Force. There are 4 plenary meetings. But in between those meetings, you have what you call face-to-face meetings and review steps. So basically, you're being constantly monitored on your progression. The second aim of this legislation is to comply with another form of supervision, which is called the Global Forum Supervision. The Global Forum is a combination of 154 countries that have organized themselves under the OECD through the G20 management, and that G20 management says that their aim is to erode and move away from and to eliminate harmful tax practices, tax evasion, money laundering, financing of terrorism, and corruption. And basically, in the Global Forum environment, you're being invited to submit yourselves to tax transparency, because the philosophy of the Global Forum, much like the philosophy of the FATF, the philosophy is if you can follow the money, if you have transparent purpose in money transactions, you have a chance at eliminating harmful practices. After all, trillions of United States dollars per year are caught in illicit flows, in tax evasion, right here in Trinidad and Tobago. Our energy spotlight has demonstrated that our country loses approximately $16 billion per year in transfer pricing. US. $16 billion per year in transfer pricing. So imagine if there's transparency in taxation, what it means for the people of Trinidad and Tobago in catching the flows that ought to be subjected to the public purse collection. That's the second obligation, the Global Forum. The Global Forum, like the Financial Action Task Force, has peer reviews. Countries come in and assess you and look at you and see how you're going along. There's a first phase peer review, a second phase peer review. They look at your technical compliance. Do you have laws to achieve the purposes? And do you have efficiency from those laws? And what they're looking for is something called common reporting standards or automatic exchange of tax information. Now, that is not something that is new to our jurisdiction. The exchange of tax information became a feature of law in 1989 when we passed the Tax Information Exchange Act. And in 1989, we saw the first Tax Information Exchange Act come. It was an umbrella created that all entities which wanted to exchange tax would come in as an order under that umbrella law. And in that first 1989 situation, which came into effect in 1990, we received the United States Intergovernmental Agreement in 1989. If you were going to do agreements in any other jurisdiction, you needed to bring another order, have the Parliament debate it, make it domestic law as opposed to international agreement, and then it got parked under that. When Trinidad and Tobago came upon last year its obligation to operationalize the Intergovernmental Agreement for the Tax Exchange for FATCA, that's the second United States law, the Parliament was asked to consider amending the Income Tax Act, the Financial Institutions Act, the Tax Exchange Information Act by bringing in another order. The opposition took a different point of view, said to the government, we will no longer have these golden umbrella shapes. You must make each law specifically. And so the Parliament went into Joint Select Committee, and that law was refashioned to repeal the tax information umbrella formula and come with a single law. We cautioned as a government then, but we required special majority support, that we had the Global Forum obligation. And the Global Forum obligation came into Trinidad and Tobago through several key milestones. Those key milestones were in 2010, we agreed to undergo the Global Forum peer review under the previous government. In 2011, Trinidad and Tobago underwent in January 2011 its peer review phase 1 report. that was approved by the cabinet of the government then sitting. In June 2011, we were informed of the conventions that require us to get there, and we were told that Trinidad and Tobago needed to negotiate 13 versions of tax information exchange. In other words, then, 13 types of FATCAs. The government agreed by way of 2 successive cabinet notes in 2011 and then again in 2014. The government then sitting agreed to the policy that Trinidad and Tobago would commit itself to do that. The government sent then Minister of Finance Larry Hawaii to Berlin in October 2014 and signed on to the high-level commitment and committed Trinidad and Tobago to common reporting standards, automatic exchange of information on the back of 13 negotiated versions of intergovernmental agreements, FATCA style. And then in 2015, we had a change of government. And in 2015, in October 2015, the Minister of Finance was met with a statement by the Global Forum to say, your country is non-compliant. Show us your 13 negotiated agreements. There were no 13 agreements to be found. We had to go into the Global Forum and ask if there was a way to remedy this situation. They said to us, apply to us for assistance. We applied for assistance by way of immediate contact, high-level commitment. The Global Forum came to Trinidad and Tobago. We negotiated and worked with them. And they said to us, you need to develop 3 pieces of law. On the one hand, you need to have a law to dismantle your secrecy provisions, specifically found in your Income Tax Act. On the second hand, you need a law which treats with adopting a multilateral convention, because you can no longer do the 13 treaties because you just don't have the time to negotiate 13 treaties. So take a multilateral approach. But to do that treaty, you also need to have your tax information exchange laws, which is just simply a version of what we did for FATCA. They said specifically, draft this and let's have a look at it. And once drafted, they then explained to Trinidad and Tobago that you cannot get into the treaty, the multilateral treaty, unless you amend your Income Tax Act. Now let me put it in very simple terms. If you were to imagine that your treaty is an agreement to cook a turkey, you have to have a turkey. So your multilateral convention is the turkey. That goes into one piece of law. Your Tax Information Exchange Act has to adopt the turkey and put that into law. And what the Global Forum said to the country is, you cannot sign on to that convention until you amend your Income Tax Act, because the process for signing on to the convention means you have to apply to be considered to sign on to the convention, and then you must be invited to sign on to the convention. And you can only be invited to sign on to the convention when you have amended your Income Tax Act. So the second purpose was Global Forum. The consequences of non-compliance are glaring, because in the report, the published documentation coming from the OECD, coming from the G20, there's a table of 8 lines. In the 8 lines of publication to the world at large, the last line in black has one jurisdiction, Trinidad and Tobago, non-compliant. The only country out of 154 countries in the entire Global Forum pot that is completely non-compliant. To get to this position, the government invited the Global Forum to come in, and very specifically, we invited the Global Forum to not speak to the government alone. We said, please speak to our opposition as well. And the Global Forum went and spoke with the opposition. As a step of goodwill and demonstration, because these countries, as I've explained in the FATF world, they want to see you making best efforts. You write to them, as the government did. You said, we will put these into our parliamentary cycle. We were given the recommendation to pull out the Income Tax Amendment Act, and so that came out into point. The third aim of this bill is to treat with the current criminality in Trinidad and Tobago. Madam Speaker, the time is different between both houses. What time do I finish, Madam President?
1 minute past 3.
Thank you very much. The third purpose of this legislation is to treat with the homegrown situation. We need only look at the statistical information in Trinidad and Tobago. We need only look at our financial intelligence unit, and we need only look at the suspicious transaction activity and the suspicious activity reports which the FIU produces to understand what we're dealing with. Nobody engages in crime unless it's a crime of passion, for vengeance specifically, unless there's profit in it. Drug dealing is profitable. Arms, profitable. Kidnapping for ransom has a money value attached to it. Marijuana sales, money value attached to it. Money laundering, there's a tax taken for it. There is money in crime. And Trinidad and Tobago has been witnessing a situation where our people feel a sense of hopelessness. We have the mantra, if you do the crime, you should do the time, but nobody sees the time because our criminal justice system, in the most important case standing by way of example of matters which are yet to be addressed, is our Piarco Airport inquiry. On the one hand, in that instance, people deserve the right to be vindicated as accused, or justice needs to be carried out through due process, and I'll say no more because it's before the courts. But what I can say is that with a construction date of 1999, we're now in 2018, and we're still in the magistracy on that matter. That's our system. We as a parliament are trying to better that. We as practitioners are trying to better that. But in Trinidad and Tobago, our financial intelligence unit produced a report last year saying, in the period 2011 to 2016, if you aggregated all suspicious transactions and all suspicious activity reports, that the total dollar value of that is $4.5 billion. And they went further, having been given additional resources by this government. They said that in the 1 year, 2016 to 2017, the total value of suspicious activity and transactions was $22.5 billion. And they disaggregated that amongst transactions to show where the dollar value was in fraud, in forgery, in attempted money laundering. And as a result of their reporting of activities, the government saw the FIU able to stop $13 billion of that suspicion activity. So this law, in the third limb, which supports the aim and purpose, is designed to tackle the criminality that is to be found with money. And as is no secret, having spent our time in the first part of our tenure addressing the criminal justice system, tightening the system, putting in rules, creating more courts, expanding judicial capacity, creating divisions. The other aspect that we went to, and where this Parliament and this Senate will be very occupied, is in the follow the money legislation, where we can say to Trinidad and Tobago, let's take a leaf out of the case in Al Capone, who didn't go down for murder or being a mobster, but who went down for tax evasion. And we genuinely believe that as a government, following the money brings relief. So those are the aims and objectives of the legislation. The parliamentary journey to get us here involved us putting a bill alongside two other hypothetical formulae. That bill went into this Parliament on the 25th of May 2017. We were referred to a Joint Select Committee. The Joint Select Committee engaged in activity over the period May, June, July, August, September, October, November. On the 2nd of November, a report of the Joint Select Committee was produced. That report was not a unanimous report. That report contained a minority report from the members of the opposition. The members of the opposition did, however, from the report, unanimously agree to send the report to the Parliament. The minority report focused on a few areas. In particular, if I were to summarize what I understand the submissions of the opposition in that report to have been, they included need for a judicial scrutiny with respect to Clause 5 of the bill, where the Trinidad and Tobago Police Service is receiving tax-paying information. The second position coming from the opposition was take a look at the South African law for that model. The third position coming was let's talk some more. We went to the House of Representatives. On the 2nd, we debated that report. More time was requested. We adjourned that to facilitate discussions between opposition and government. We exchanged in communications between opposition and government, and on the 23rd of November 2018, we came back to the House. On the 23rd, we were told that there was need for more consultation in a committee. The reporting deadline for Financial Action Task Force was the 30th of November, which I'll explain in a moment. The reporting deadline for the Global Forum was the 30th of November. With that in mind, we could not establish a joint select committee. Number one, there were new independents, and committees had to be populated. Number two, the process of appointing a joint select committee meant we would have to have come to the Senate, appoint a committee, come back to the House, and then the committee would have sat after the 30th of November. Stick a pin. This reporting deadline. The Financial Action Task Force request for ratings review. Remember, I explained that there was a process that you have to go through of being constantly monitored. The deadline for that in the written communication coming from the Financial Action Task Force through the Caribbean Financial Action Task Force was originally November 22nd, 2018. We requested an extension of time to the 30th. If you don't request your re-ratings for the elements that you've done badly in, those 40 recommendations and 11 immediate outcomes, you are going to slide from the non-compliance grey list into the blacklist. And that's an immutable deadline. We disclose that deadline, we put it out into the public domain, and for the Global Forum, the request for peer review in January had to be communicated by the 30th. On the 23rd, we therefore went into a special select committee. The opposition said to us that they would not participate in that special select committee. In the special select committee, we brought forward a barrage of stakeholders into the public domain. And in the public domain, I say that disaggregating the consultation, obviously, which a bill has beforehand, we had the benefit of the National Anti-Money Laundering Committee. It's called the NAMLAC Committee. That committee is comprised of the DPP, the FIU, the Financial Investigation Branch, the Chief Immigration Officer, Controller of Customs, Ministry of Finance, the Director of Central Authority, the Ministry of the Attorney General, the Central Bank, the Securities Exchange Commission. All of them came. The Bankers Association came. The European Chamber of Commerce sent in their commentary. The individual banks came. The American Chamber of Commerce came. The Trinidad and Tobago Chamber of Commerce came. And every single person, to an honorable man and woman, said that they agreed with the provisions of the law in the clauses as they then stood, which were 10 clauses. We came back to the House on the 30th of November, the day for deadline. We were met with the opposition categorically stating through its leader of opposition that they would not support the legislation. The legislation as presented in the House involved 10 clauses. The first 5 clauses, which are in this bill, were, as it relates to the first 4 clauses, innocuous. Long title, short title, this act shall mean the Income Tax Act, this act shall come into operation on a date for proclamation, and then the next clause, the 5th clause, was to put into effect what I call existing, safe, simple majority law. It's to be found in this bill. The clause that related to that is to be found in this bill, and specifically is to be found at Clause 5 of the bill. At Clause 5 of the bill, we propose an amendment to Section 4. Section 4 of the Income Tax Act is the section in subsections 1 and 2 that provide the secrecy provision prohibition. Prohibition of breaching secrecy. We proposed, because of the recommendations coming out of the Financial Action Task Force, specifically recommendation 40 in black and white in the mutual evaluation report, in several paragraphs in black and white in that report, and associated with immediate outcome 2 we were told that we need to make sure that law enforcement has the opportunity to treat with criminality under the income tax legislation. Section 4, we proposed to amend, forgive me, it's in clause 4 of this bill. I'm confusing it with that in the House. In clause 4 of this bill, we propose specifically the following. We propose to insert a new subsection 4. And we say, with respect to subclauses 1 and 2, that they don't apply in respect of, listen to this, criminal proceedings, either on indictment or summary conviction, hear the words, that have been commenced by the laying of information or preferring of an indictment under the Proceeds of Crime Act or the Anti-Terrorism Act. We go on, subclause 5. Notwithstanding 1 and 2, which is the secrecy provisions, where, and I'll put the emphasis, a written law authorizes disclosure by the board, and that's the Board of Inland Revenue, of any taxpayer information to an individual or entity, the board shall within a reasonable time so disclose to the individual or entity, and the individual or entity shall in respect of that information so disclose, comply with subsection 6. Subclause 4 translates to the fact that criminal proceedings, that you can obtain taxpayer information. That is the existing law. It meets a number of requirements for the new senators joining us. Permit me, Madam President. We often refer to the proportionality of law. Proportionality is a legal test which the Parliament is required to observe as well, that says you have a legitimate aim, you are intruding on rights effectively only so far as you need to, that the intrusion is proportionate or required in a society such as ours. There's been umpteen case law on it. In the Privy Council, the leading authority is a case called Surat. We have cases like Northern Construction. In Trinidad and Tobago at the appellate level, there are a number of other cases to treat with the concept of proportionality. And effectively, Baroness Hale is trumpeted in the Surat case as saying that the golden test is that you're proportionate. And it matters not if you traverse a section 4 and 5 right of the Constitution, necessarily that you have a 3/5 majority. Because if you're only going so far as the existing law recognizes and it's proportionate, not every entrenched right in 4 and 5 requires necessarily a 3/5 right. It was cutting-edge law at its time. Indeed, our own Court of Appeal had a different point of view in a minority decision, but suffice it to say that's the law in Trinidad and Tobago. But in any event, this is existing law because under the Proceeds of Crime Act, in Section 32 of the Proceeds of Crime Act, you have the ability to have a production order coming out of the Proceeds of Crime Act, which allow the Board of Inland Revenue to receive information. Now, one may easily ask, well, why do that in this law if the Proceeds of Crime Act says that? And the answer is quite simply because the international assessors have said, out of an abundance of caution and to avoid any ambiguity, or worse yet, to avoid people the opportunity to argue a case which is possibly going to take years to come out, put it in your primary law. And that's what we did. Subclause 5 says where a written law authorizes disclosure. Well, there are only 2 types of written law that can authorize disclosure. On the one hand, it is law which is passed with a special majority, which gives the disclosure. For instance, FATCA. FATCA does that. But on the other hand, it relates to what we call saved law. Saved law is law which is pre-1962 Constitution, and therefore that law is preserved, notwithstanding the passage of your Constitution, similar to our ability to hang people still, even though it may be viewed to be contrary to the Constitution as crafted by our predecessors. Subclause 6. Notwithstanding subsections 1 and 2, a person having an official duty or being employed in the administration of this Act shall, for the purposes of subsection 5, they shall do 2 things. A, give the FIU the information. The FIU, the Financial Intelligence Act, as an act of Parliament in 2009, in compliance with our FATF third round obligation, passed by a then PNM government, has a secrecy provision. You're allowed under the FIU legislation to get that. The opposition, under the hand of Senator Saddam Hussein, said to us, look at the South African law in the minority report. The South African law is exactly the same as that. Existing law, safe provision and secrecy provisions, law which is passed with a 3/5 majority, no need for special majority. B, provide taxpayer information to a member of the police service. Now, there was an observation raised by the members of the opposition which was arguable. Whilst the government held the view that the law was to be read in the round, as you always should, the opposition put forward a point of view that it could be open to abuse. And in a little bit of political tapping, some words were traded to my learned friend Saddam Hussein, who I have great regard for, but this is the cut and thrust of politics. But the simple point is that the government's point of view is that this law was designed for the purposes of fraud and criminality in that purpose, to be read in conjunction with the Proceeds of Crime Act and Anti-Terrorism Act. We took on board the fact that there could be debate over it, and we harmonized the legislation to treat with the law now in this bill before us, Proceeds of Crime Act, Anti-Terrorism Act, Prevention of Corruption Act, or involving fraud or dishonesty. Again, this is law which allows no need for special majority, because again, it is permitted within the realm of what our law allows right now. We've gone a step further in adding in a hurdle in a new clause 6A, which says that a member of the police service, if you want to go for this, if you want to access taxpaying information, do so by judicial permission. And the judicial permission that we have applied is ex parte, without notice. For the non-lawyers amongst us, ex parte means one person alone can go to court without the other side, and you don't need to serve them with notice of what you're doing, because what will happen is you'll blow the whistle and they're likely to run away with the thing that you're looking for, or to come up with some obfuscating reason as to why it should be something other than what it potentially is. The question arises in that whether one ought to introduce a burden of proof. We did not include a burden of proof specifically. We've sought to rely upon the common law, because the observation of difficulty coming from the international assessors with respect to our Proceeds of Crime Act Section 32 is that the reasonable grounds expressed there are complicated and time-consuming. One could argue that mere suspicion is not enough, as happens, for instance, in Norwich pharmacal applications where financial institutions hand over information on a different standard of proof. Certainly a balance of probabilities, which is the civil standard, is too high. A prima facie case is also close to an arguable case, which is again too high. And what you're really looking for is to allow the judiciary the opportunity to develop the law by establishing what its standard is, because you need only hang your hat on the point that a judge must be satisfied with what has come before the judge in the request for production. So we're skirting a careful line. And the careful line that we're skirting is that the assessors tell us, please don't replicate the Proceeds of Crime approach. The assessors effectively want the information ex proprio motu, of their own volition. I have only a few minutes, I won't give way. I apologize, I normally would. So, Madam President, the burden and standard of proof, I'm sure, is something that will engage this House in debate. I certainly wanted to raise it up front. It isn't through lack of concentrated effort that we have not treated with it in an express fashion. We have adopted instead the same language recommended to us by Senator Saddam Hussein, coming out of the South African law, where there is no express standard in the law. And I think that that's a useful formula to allow the courts from time to time to maneuver. Madam President, we go into Clause 5 to put in, again, things which relate to proportionality, meaning there's balance and that there's measure. Senator Mark is going to chastise me, but please.
No, I just wanted on a point of clarification before you finished, Honourable Minister. Could you, at some point in time, indicate what the implications of the removal of the 5 clauses that you had to take away because you couldn't get the special majority.
Sure.
What would that have to do with the aim of the bill in the first place?
Sure.
Thank you.
Very good question, and perhaps I should dive to that now. I'll just quickly traverse this. We provided proportionality in Clause 5 by providing the fact that you have a limited purpose. You can only use it for certain things. You can't go out with the purposes given to you. You can't just give it to people. And importantly, that you commit an offense if you do it in the wrong way. We took the recommendation coming from Nirad Tiwari, the CEO of AmCham, asking us to raise the offenses. We thought that Mr. Tiwari's recommendation, even though in opposition to another person's recommendation, was a good recommendation. And that is followed by an explanation in terms of definition as to what taxpayer information is and what statistical information is. Excellent question, Dr. Dylan Remy, Senator, Honorable Senator. The 5 clauses that were removed were amendments to sections of the Income Tax Act, specifically sections 117A and section 93. And those were specifically to allow something which the entire Trinidad and Tobago Parliament has already agreed to. We agreed in the financial action, in the FATCA, the American Tax Reciprocal Arrangement, in the FATCA Act number 4 of 2017, this country, this Parliament, this opposition, this government, an independent bench.
Attorney General, you have 5 more minutes.
Thank you, Madam President. Agreed that we would allow for the competent authority of the Board of Inland Revenue to exchange taxpayer information without consent with another competent authority. And the amendments that we proposed in clauses 6, 7, 8, 9, 10, we kept some of 6, we kept the offenses. But the rest of it, even though it is illogical in the extreme to understand why we cannot agree to put in a formula exactly as FATCA, to say you don't need consent and you don't need the exception to the Data Protection Act. Even though we said that already and agreed it in principle, regrettably we could not achieve the 3/5 majority support with the opposition, and it therefore had to be excised. The effect of that is that the Global Forum, in particular, may well come back to us, because we can only now turn a key. If this Senate passes law, as I pray it will, we'll be able to send the act to the Global Forum, ask that we sign on to the treaty. They may very well tell us, well, look, you need to amend the things which we thought you had there before, and which we commented on, and which we approved on. And then we will have to answer them and say, well, you know what? I strategically believe that it can be included in the Tax Information Exchange Bill, the other one. Because in the American FATCA Tax Information Exchange Bill, we amended the Income Tax Act and we amended the Financial Institutions Act. So I potentially have another bite there. But I could not get to them, the country could not get to them unless we presented them with enacted law. Only the enacted law allows you to get the agreement, the multilateral convention. Only the agreement allows you to put it into the legislation in the bills number 2 and 3, which are in Joint Select Committee. So it's logical and sequential in its approach. The clauses which mirror those clauses taken out are to be found. Clauses section 7, 8, 22, 24, etc. of the FATCA law. If you look in the FATCA law, you will see, notwithstanding section 4 of the Income Tax Act, notwithstanding several sections of the Data Protection Act, sections 4, 30, 31, 46, 96, notwithstanding the Data Protection Act, and notwithstanding the Financial Institutions Act, you can reciprocally exchange information without consent. So that's been done already. And this law can be carved separately because there's no need to consider them, because we're conceptually, had we agreed to the bill in the House as it was, we would only have been saying, if your tax information exchange laws allow you to exchange that information, you will not breach the Income Tax Act. So there was no jeopardy at all, because it was something which this Parliament would have to have approved by a 3/5 majority anyway. For the life of me, I can't understand the opposition to it, but this is our democracy, this is our parliament, this is the rules of engagement. They are enshrined in the supreme law of the Republic of Trinidad and Tobago, so declared under Section 2 of the Constitution, and that is the requirement pursuant to Section 13(1) of the Constitution of Trinidad and Tobago that says if you're going to trip a 3/5 right, you need the majority support. So, Madam President, I dare say this law is for legitimate aim in 3 purposes described: FATF, Global Forum, Trinidad and Tobago's crime fighting follow the money. This law is proportionate. It does not require any special majority. This law is intended to feed Trinidad and Tobago with the opportunity to have a fighting chance. I heard Prime Minister Mia Mottley yesterday at CARICOM say, claim the ground you have, and then move on. It was this government's opportunity to claim the ground we have, to write to the Financial Action Task Force as we did on Friday, November 30th, and God willing, if this House approves, if the Senate approves this bill, to give us that fighting chance to say to the Global Forum, take us seriously. Because their view of us is not as partisan politics. They will say to us, you had 10 years, 8 years, 2 years prior to 2010 of knowing that it's coming, from 2010 to 2018, 8 years, government commitments, cabinet notes, etc. You cannot come to an international body and say 8 years is too much for you when you're the only person in blacklisted non-compliance. They look at you, as we say proverbially, cocky eye. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Income Tax Act be now read a second time. Senator Ramdeen.
Good afternoon, Madam President. Madam President, it's a privilege to join this debate and on behalf of the opposition to reply to the Honourable Attorney General in a bill entitled the Income Tax Amendment Bill 2018, a bill which is only 5 clauses, but which, Madam President, has serious implications for the citizenry of Trinidad and Tobago. Madam President, there have been a number of persons have spoken on the history of how this legislation has arrived to the Senate. And the Honourable Attorney General will correct me if I'm wrong, but on the 2nd of September 2016, at the invitation of the Leader of the Opposition, the Honourable Prime Minister and a team from the government met with the Leader of the Opposition and a team from the opposition. And there were 2 very important issues that arose out of that meeting. One of those issues was in relation to this piece of legislation. The Attorney General will recall he was sitting at the side of the Prime Minister, and the parties agreed at that meeting. There was agreement that with respect to the FATCA legislation that the Attorney General foreshadowed was coming soon, and the Global Forum that was coming shortly thereafter, that the approach of the government and the opposition to this most important matter would be one of collaboration, where a member of the government will appoint a member and the opposition will appoint a member, and before the legislation actually reaches to the Parliament, all of the communication in relation to this piece of legislation would be shared by the government with the opposition. Needless to say, Madam President, the second most important matter that arose out of that meeting in September of 2016 was that in addition to that undertaking given by the government through the Honourable Prime Minister, the second undertaking that was given to the opposition was that the chairmanship of the Joint Select Committee on National Security would be put into the hands of an independent senator. Madam President, I am not very pleased to be here standing in this debate and to announce to you that those 2 undertakings given by the government with respect to how we should proceed with respect to legislative matters and the business of the people in the Parliament of Trinidad and Tobago were never kept by the government. And that is the starting point of why, whenever the government comes and tells the opposition They are going to proceed down a particular path. They are going to organize the people's business in a particular way. We always have the suspicions that the government is not going to keep their word, and the only thing that they do keep is the fact that they don't keep their word.
Consistently.
Now, Madam President, this piece of legislation, the Attorney General has made heavy weather in the other place and in the public domain about the fact that the opposition has proposed no amendments to this piece of legislation. And in preparing for this debate, Madam President, I was trying to think up of an apt analogy to explain why the opposition has not proposed any amendments to this piece of legislation. And Madam President, in another incarnation, you know that for those of us who are versed in the law, when you have a running down action and you get in the accident and the vehicle is damaged too badly, they call it a write-off. It have no way you could repair it. And you know, that is the analogy I want to use with respect to this piece of legislation. It's like a write-off. You can't repair it. It doesn't make no sense.
No seriousness.
It don't make any sense you try to repair it. It's beyond repair. So, I want to start off by saying that. The next thing I want to say is this, Madam President. Madam President, I think with the experience that I have, I understand how important the office of the Attorney General is in our democracy. The Attorney General, I've said more than once in the Senate, is the guardian of the public interest. Under Section 76 of the Constitution, the Attorney General is in charge of the legal affairs of Trinidad and Tobago. By virtue of his cabinet position, the Attorney General is a legal advisor to the government and to the cabinet. But you see, Madam President, the Attorney General doesn't operate on his own, you know. The Attorney General is part of a cabinet, and the Attorney General is the head of a ministry. And as I have said before, I and the Attorney General will part ways on this one. The Attorney General will defend the legislation that he's brought to the Parliament. It is my role to examine it critically and to point out whether I think that that legislation is good law or not. But, Madam President, I have been in this Senate, and I have seen legislation brought to this Senate that has been struck down by the High Court. We recently participated in a bill in this Senate that we passed, where if it wasn't for the opposition, the Land Tribunal Bill would have allowed people to occupy lands without even the intention to possess. The drafters of the law did not include the mental element in that particular piece of legislation. Why go to that, Madam President? It's very important. Because I will listen to the Attorney General defend his staff and the office of the Attorney General. But there are serious implications when you bring legislation to the Parliament that is not properly researched, that is not in accordance with the law, that is not in accordance with the Constitution. The Attorney General said this afternoon that the reason why we must operate, we have these amendments to the Income Tax Act is because the Global Forum told us that the provisions in the Proceeds of Crime are not good enough. The exact words were that they are too complicated and burdensome. Madam President, I want to say that we make no apology in this opposition. We are not a democracy that is based on the Global Forum, you know. I understand that Trinidad and Tobago is part of a global forum. And there are certain obligations, international and otherwise, that will affect us. But at the end of the day, the supreme law of Trinidad and Tobago is the Constitution, not the Global Forum. That's right. And we depend upon the Attorney General to stand up to anybody, global, regional, or otherwise, who wants us to undertake a process and make part of our law something that doesn't accord with the Constitution and the fundamental rights. We cannot subscribe to that. And if it is that is the position, Madam President, we cannot support legislation that seeks to diminish or undermine the fundamental rights that are guaranteed to each and every citizen of this country. The Attorney General is entitled to bring legislation that requires a 3/5 majority. But that legislation, Madam President, is legislation that will require the support of the opposition, and it must pass the Section 13 criteria in the Constitution. So I want to get down to these clauses that the Attorney General has outlined here today in these 5 clauses. I want to start, Madam President, with the Constitution. The Constitution, by Section 2, recognizes that the Constitution is the supreme law. Section 4C guarantees the right of the individual to respect for his private and family life. It guarantees his freedom of thought and expression. These are rights that are guaranteed under the Constitution. And let me get down straight into this business about Surat, because I come here today to deal with Surat. Madam President, every time that we have a debate in the Senate, Surat appears. Why? No problem. Surat is a leading authority in our jurisdiction, Madam President. So let me get down to what Surat means. Surat is a Privy Council decision from the Judicial Committee that is cited at 2007 UKPC at 55. And let me get down to paragraph 58, which is what the Attorney General rests his case on today. This is what Lady Hale had to say about this idea of a 3/5 majority and absolute rights and qualified rights. It cannot be the case that every act of Parliament which impinges in any way upon the rights protected in sections 4 and 5 of the Constitution is for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. These are both qualified rights, which may be limited either by general legislation or in the particular case, provided that the limitation pursues, and this is the important part, Madam President. Every time we hear about this Surat, these are both qualified rights, which are limited either by general legislation or in a particular case, provided that the limitation pursues a legitimate aim and is proportionate to it. It is for the Parliament in the first instance to strike the balance between the individual rights and the general interest. The courts may on occasion have to decide whether Parliament has achieved the right balance. Madam President, to break that down for those who are not lawyers, it is recognized that the rights that are guaranteed to the citizen under Section 4 and 5 are all qualified rights. Even the right to life is a qualified right, because it can be taken away with due process. Nobody could argue otherwise. After Surat, they had Omar Maraj. That sealed the cake on that. But Madam President, I listened to the Attorney General in the other place. And up to yesterday, I was asking Senator Saddam Hussein if he could help me to get the Hansard as to what was said by the Attorney General. Repeated it today. So I couldn't believe it when I heard it the first time. So I said, let me just get the Hansard to make sure that the Attorney General actually said what I thought he said. And the Attorney General said, Madam President, I was looking at it on TV, and the Attorney General was, listen to this, listen to this, listen to this one. So,
be very specific when you're quoting, because sometimes you're saying, listen to this, listen. Is that what the Attorney General said, or are you saying, listen to this, and now you're going to quote?
No, I'm going to quote it now, ma'am.
Right. So I'm asking, in your contribution, when you're going to be quoted, lead into the quotation, please, properly, so that we can all understand where you're coming from.
I'm obliged, Madam President. I'm obliged. So, this is what the Attorney General said. Hear this. This is the quote. Hear this. Subsection 4, subsections 1 and 2. That is the secrecy provisions. Do not apply in respect of criminal proceedings, either on indictment or summary conviction. Hear this. That have been commenced. You know what that means? No special majority, because a court has an inherent power to compel the evidence by due process. No special majority. Subsection 5. Then the Attorney General said, and I quote, Now clauses 6, 7, 8, 9, and 10, these require special majorities. But Madam President, listen to this. Subclause 6, and some of it can be disaggregated to be kept with no special majority. 6, 7, 8, 9, 10 are all word for word conceptually from the FATCA bill, which the opposition agreed to. And this is the part I want to pay a little attention to. So the thing which they are tripping over and complaining about as requiring a special majority doesn't require it. The big issue with the police, we need the police. If we put in judicial authorization, listen to this, we satisfy proportionality within the concept of Baroness Hale in Surat. All right, Madam President. So the Attorney General tells us then and today, he says, you're putting this thing called judicial scrutiny, that's proportionality. Madam President, the reason why I went into all of this history is because of this. The Attorney General is only as good as the team that he has. It's just like the government. They are only as good as the team that they comprise collectively. Right? I'll tell you how great the team is just now. So, Madam President, I sat down and just wanted to bring this home to the population. In this cabinet that constitutes the government of Trinidad and Tobago, they have the Honorable Attorney General. He's a lawyer. They have the Minister of National Security. He's a lawyer. They have the Minister of Housing. He's a lawyer. They have the Minister of Public Administration. She's a lawyer. The Minister of Agriculture. He's a lawyer. The Minister of Health. He said he's qualified to be a lawyer as well. The Minister of Finance. He have 2 LLMs. And the Minister in the Office of the Attorney General. He's also a lawyer. So in this cabinet, you have 8 lawyers. 8. Sorry. 7.5. It's 8. Planning too? 8. Planning is a lawyer too. Thank you, Minister of Agriculture. So 1/3 of the cabinet is like a law school. Is that 1/3 of the cabinet are lawyers? Madam President.
2 geologists.
But that's helping all when it comes to that really helping all. You shouldn't be boasting about that. But anyway, they have 9 lawyers in the cabinet, Madam President. Madam President, you know what really bothers me about this legislation? You have 9 lawyers in the cabinet. More than 1/3 of the cabinet are lawyers. But the Attorney General and this legislation has to pass through the cabinet before it comes to the lower house and before it comes to the Senate. The Attorney General, under our democracy, has to go to the cabinet, get cabinet approval before bringing it to Parliament. Take your time. Let's take your time. You got a chance.
No rush, no rush.
Madam President, how anybody could say that putting in the clause that requires judicial scrutiny, satisfies proportionality? Well, I don't know.
It can't.
Right? I just don't know. I mean, I know a little bit about law, a little bit. So I just do a little reading here and there and try and come up with a good idea now and then. But, you know, Madam President, they had law beyond Surat, you know. It had law beyond Surat. So I came across this case called Bank Millet and Her Majesty's Treasury. It's a decision from the Supreme Court in 2013. The United Kingdom Supreme Court, Madam President, was deciding a matter almost as serious as what was going on here that we are asked to decide as a parliament. And it baffles me how every single constitutional textbook, everyone who could read, Madam President, this is a leading case on proportionality in the Commonwealth, and nobody bothered to read it? Seriously? Nobody bothered to read it so that they could come here and tell us whether this piece of legislation that I agree the requirements are it must pursue a legitimate aim and it must be proportional. If it doesn't do that, Madam President, then you need a special majority to pass it. So, what is this thing called bank millet? You know this case was about, Madam President? I tell you, just give me a little time to explain how serious this thing is. This case called Bank Millet was about people who were financing terrorism and a nuclear program in Iran. And you know what the United Kingdom started to do? Exactly what we are required to do here by virtue of the United Nations General Assembly. So, I know I have limited time, Madam President, but allow me to read just the opening of the speech of Jonathan Sumption, soon to be the ex-president of the United Kingdom Supreme Court. And I want to rely on what Justice Sumption said, Lord Sumption said, sorry, because I think he also knows a little bit about this. The proliferation of nuclear weapons is an international issue of great importance to the security of the United Kingdom and the international community. For a number of years, Iran has been a major industrial program with the United Kingdom, along with the rest of the international community. There were certain United Nations Security Council resolutions, 1737 and 1747, that banned these countries from doing business with the entire international community. I was going to get on to the business of this thing, before I run out of time. There was, just to emphasize how important this case was, there were 9 members of the Supreme Court sitting on this matter. And let me tell you what the court had to say about this thing called proportionality. Listen to this, Madam President. When the Attorney General and the government in particular tells us, throw in a little judicial scrutiny, that is proportionality, no big thing. Let me tell you what the Supreme Court was saying. The requirements of rationality and proportionality as applied to decisions engaging the human rights of applicants inevitably overlap. The classic formulation of the test is to be found in the advice of the Privy Council delivered by Lord Clyde in a very important case called De Freitas and the Permanent Secretary of Ministry and Agriculture. That is where this all started. But this decision, although it was a milestone in the development of the law, is now more important for the way in which it has been adapted and applied in the subsequent case law. And then they have a number of cases, the most important of which is a case called Huang and the Secretary of State for the Home Department, 2007, 2 appeal cases at 167, and a quote from Lord Bingham. But listen to this, Madam President. When we are told, just slap in a little judicial scrutiny and you're on your way, the effect can be sufficiently summarized for present purposes by saying that the question depends on an exacting analysis of the factual case advanced in defense of the measure, that is, in defense of the legislation. And this is what you must satisfy. Whether its objective is sufficiently important to justify the limitation of the fundamental right, whether it is rationally connected to the objective, whether a less intrusive measure could have been used, and whether having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. Now, Madam President, if that is the test of what is proportional in law, expounded by the United Kingdom Supreme Court, the same people who sit on the Judicial Committee of the Privy Council, how can you possibly come here and tell us we have judicial oversight, therefore it's proportional, and we must accept that?
Never.
Nonsense. Nonsense.
Can't accept that.
Madam President, in this particular matter, you know what the court said? These 4 requirements are logically separate, but in practice, they inevitably overlap because the same facts are likely to be relevant to more than one of them. What this requires, Madam President, is that the government must come and show us that these aims of the legislation that the Attorney General has set out, which is the requirements of FATF, the reporting requirements of CFATF, the Global Forum, and the homegrown situation, according to use the words of the Attorney General, allow us to intrude on these rights. The Attorney General says, you don't need no special majority. No problem. Madam President, in this bill, section clause 4, which seeks to insert subsection 6b, provides, notwithstanding subsection 1 and 2, a person having an official duty or being employed in the administration of this act shall, for the purposes of subsection 5, provide taxpayer information to a member of the police service of the rank of superintendent or above, attached to the division or unit of the police service responsible for financial investigation or fraud, where such information is required for the purpose of investigating whether an offense under the Proceeds of Crime, Anti-Terrorism, Prevention of Corruption, or involving fraud or dishonesty. Madam President, so we understand proceeds of crime, anti-terrorism, prevention of corruption. Now we come down to this omnibus thing about involving fraud or dishonesty. Well, Madam President, how that could ever be the least intrusive way in which this right, because despite what the Attorney General has told us, any provision of information pursuant to this legislation by any member that is of the police service, any request by any member of the police service, breaches your right to privacy from the time the information is provided. There's no doubt about that under the legislation. The Attorney General has not come with asking for a 3/5 majority. So in accordance with the law, the Attorney General must demonstrate that this law, as it stands, pursues a legitimate aim. I'm not on that, but it is proportionate. So, Madam President, how is it that we can give power under this piece of legislation for any offense involving fraud or dishonesty? Madam President, I wanted to bring home how this piece of legislation can work in reality. So let me give you a real-life example of where this could apply and how it could apply. I am a lawyer. I have a land development. I put in down foundation on my land development. A partner of mine doing a construction for the government on some other project. And I tell him, well, you know what? You have extra material there. Bring it on my land development now, and we could always put down the foundation. So my partner take the material, gravel, sand, overburden, bring it on my land development. And as we know, that is unlawful. But that don't have anything to do with fraud. Sorry, that don't have anything to do with anti-corruption. That don't have anything, well, it might be if you are a person in public life, proceeds of crime, terrorism, prevention of corruption. But you know, Madam President, under that factual scenario, the police can go and ask the BIR for my information because it involves dishonesty or fraud. So I want to say at the very outset, Madam President, you see this clause that this legislation has on page 2, subclause clause 4, subsection 6b. No matter what the Attorney General tells us, that requires a special majority. In the current form, I can say on the authorities, the law as it presently stands, from the highest court, because the next thing somebody might come and say is, well, you know, Ramdeen citing a Supreme Court decision, that don't bind us and that kind of thing, Madam President. So let me just tell you that in Privy Council Appeal 2016, UK PC 30, Madehu and the State of Mauritius, a decision of Lord Hodge, delivering the advice of the Judicial Committee, went into the same principles, the exact principles, and said exactly the same thing. In this particular case, Madam President, you know what you're doing in this particular case? They wanted to test whether giving somebody's fingerprint, right, had breached the right to privacy. And in this case, the same principles that were laid down in Bank Millet were applied by the Privy Council. That learning, Madam President, goes way back. The Attorney General will be very familiar with the Canadian case of Oakes. It is the classic, the locus classicus in this area. And therefore, I don't understand how the Attorney General knows Oaks, he knows Bank Millet, he knows all of these cases, and the people who are advising the Attorney General have not advised the government that the legislation that they've brought here and asked the Parliament to pass is unconstitutional. Madam President, I have sat in this Parliament for days with the government, for days fixing the legislation. And the opposition, with respect to this piece of legislation, was prepared to work with the government to get it right. This piece of legislation, you know, the government has done something that nobody thought was actually possible, Madam President, by what was done in the lower house and what is brought here today. And I mean, sometimes the government really surprises us, because we are actually in a more non-compliant position with the passage of this legislation than we were before without the passage of the legislation. So, the talent of this government and this cabinet, Madam President, unmatched, unparalleled. It really is. But, Madam President, a very, very serious matter that the Attorney General has to take into consideration, which was respectfully raised by the Attorney General, is this issue about the provisions under the Proceeds of Crime Act. And from the time I saw this legislation in its form, because, Madam President, you know, this government really breaking records. They will break the record just now for the most murders in 1 year. They will break the parliamentary record for providing a bill with the most amount of amendments, because this is the 5th version of this income tax bill that has been presented to the Parliament. 5 times. And you would think that after 5 times, you might get it right. But we still can't get it right, Madam President. Madam President, you know, we have something in this country called the Proceeds of Crime Act. The Proceeds of Crime Act, Madam President, allows the police wider powers than are given to the police in this piece of legislation. It provides a mechanism under Section 32 for a police officer to get information for a specified offense, whether a person has benefited from a specified offense, the extent or whereabouts of the proceeds of a specified offense. And, Madam President, let me just for completeness sake, so that people will understand, what is a specified offense? The Attorney General says we're doing this to go after, follow the money. You know, Madam President, nothing wrong with following the money, you know. Absolutely. But the problem is, this government is intent on following the money, but they ain't finding no money. That is the problem. They're promising to keep following, but they are finding nothing. So this idea of keep trumpeting the idea that we will follow the money, we will follow the money. The point is, Madam President, we're going into 4 years and we ain't get no finding. It's continue about following. Madam President, let me tell you, under the Proceeds of Crime, the offenses that any police officer that satisfies the requirements of Section 32, what is the offenses that they could get information on? Participation in an organized criminal group and racketeering. Terrorism, including terrorist financing. Trafficking in human beings, body parts and migrant smuggling. Sexual exploitation, including sexual exploitation of children. Illicit trafficking in narcotic drugs and psychotropic substances. Illicit arms trafficking. Illicit trafficking in stolen and other goods. Here is one, Madam President. Corruption and bribery. Fraud. Counterfeiting currency. Intellectual property offenses, including counterfeiting and piracy of product. Environmental crime. Murder. Grievous bodily injury. Kidnapping. Illegal restraint and hostage taking. Robbery or theft. Smuggling, including in relation to customs and excise duty and taxes. Listen to this one, Madam President. Tax crimes.
Any agency that?
Tax crimes. Forgery, piracy, and insider trading and market manipulation. Madam President, the Parliament of Trinidad and Tobago, the government and the opposition, passed the Proceeds of Crime to do exactly what the Attorney General has told us today that the Global Forum wants to do. But you know what they don't want us to do, Madam President? I'll tell you what they don't want us to do. When you look at Section 32, right? So there are certain conditions that are attached to which a police officer must satisfy. Correct. But you know the problem with that, AG, is this. When a police officer go and breach the law, go and get somebody information, misuse the information, you know who has to pay for it? Not the Global Forum, you know. The Office of the Attorney General. You know what that means, Madam President? Not the Honorable Attorney General. It means the taxpayers of Trinidad and Tobago. So they want to give us a recipe for disaster. But when that disaster occurs, we're not getting any help from the Global Forum to fix it, you know. It's the people of Trinidad and Tobago who must suffer the loss and take the lash for it. And the Attorney General must find himself defending it. So, isn't anybody concerned, Madam President, that this legislation we are being asked to pass in an environment where there are rampant rogue elements throughout the Trinidad and Tobago Police Service? The government doesn't like to talk about that now because they are, for want of a better word, I want to be careful how I say this, Madam President, but they want to take credit for the work of the Commissioner of Police. No problem with that. But the point about it is, Madam President, the murder is going to reach 500 within the next week. And there's no answer for that. The FIU says there are $22 billion in suspicious transactions. Nobody is getting prosecuted. The Attorney General tells us today $128 million on CLICO. Nobody can get prosecuted for that either. Probably between 2010 and now is about $500 million that was spent on one inquiry. The Attorney General makes reference to
Senator
Piaco.
Ramdeen, you have 5 more minutes.
Thank you, Madam President. The Attorney General makes reference to Piaco, but I'm sure that the money that was spent on CLICO is more than the money that was spent on Piaco between 1999 and 2018. But the problem is, Madam President, the Attorney General has set out very clearly that what this legislation requires is constant monitoring on a yearly basis. I think the Attorney General says 4 times a year in relation to 1, 2 times a year. But, Madam President, the passage of legislation without putting in place the mechanism to operationalize the legislation and bring people before the courts, prosecute people, and get evidence in a form that people can be held accountable for their actions is going to lead us just pushing the barrier one step down. Next year, when we go to see FATF, and Global Forum, the legislation is passed, but nobody is prosecuted. You have another $22 billion in suspicious transactions, and the FIU is complaining. Then where would we be? You think we're going to, this idea of, well, we get off the blacklist or the grey list or whichever list we're on, right? We are not helping the situation because, like I said in the factor debate, we shouldn't be waiting on the Global Forum to tell us we need to fight white-collar crime, we need to fight money laundering. Madam President, if you drive around this country, and see the malls and the supermarkets that are being opened up everywhere, you really think you need the police and the Global Forum to tell you who money laundering and who not money laundering? It's not no secret. It's just like the drug trade. Everybody except the police and the FIU know who money laundering and who in drugs. But nobody can be prosecuted for it. And we don't see any problem with that. Let us pass more legislation. Let us pass more legislation and let people open more malls, let them open more supermarkets, and let them wash more money to Trinidad and Tobago. And when we come and complain, $22 billion in suspicious transactions. When are we going to get a specialized unit, like Commissioner Griffith says, to deal with white-collar crime? When are we going to train them? When are we going to put them in a form that they could be able to prosecute these offenses? Nobody has thought about that. All we need to do is pass the legislation, and abracadabra, we're going to be able to pass the Global Forum, we're going to satisfy CFATF, and everything honky-dory after that. Well, Madam President, if that is the plan of the government could continue to do that. They can continue to push the boundaries one step down so that they will pass January and they will reach midterm and they will push it again and push it again. And like with the perfect example of all of this is when the government came and told us the solution to crime is the anti-gang legislation. We pass it. We give them support. And today, what is the position with the anti-gang legislation, Madam President? We are no better now, right? We are worse off with the anti-gang legislation than we were when we didn't have anti-gang legislation. So, I am not going to partake in this exercise, Madam President, to the extent of supporting this legislation, and I'll say exactly why. I know a little bit about law, I know a little bit about public law, and I know a little bit about constitutional law. And all I am waiting on is for this legislation to be proclaimed, assented to, and I head into the High Court. Because I can't do it now because it ain't passed yet. As soon as it assented to, is one place I head in, to the High Court. Because I am confident, as the law presently stands, if this legislation is passed in its current form, it's about 2 hearings and it's struck down. So, you know, Madam President, we always tell the government, pause for a pause. Do the right thing. This is serious business. The passage of legislation that infringes somebody's fundamental rights is not something to be taken, it is something to be taken quite seriously. Because the Constitution is designed to protect those rights. They are entrenched rights. You can't come to the Parliament and abuse your power as a government to be able to just railroad legislation through people's rights. Because, Madam President, the generation of today and the generation to come after us will judge us very harshly by the decisions that we make today that will affect their rights in the future. And we must be a little bit more mature about these decisions that we are taking. This is not about PNM and UNC. The Constitution is not red or yellow. The Constitution is the supreme law. The Attorney General is the guardian of the public interest. He has advisors. Go and read the cases.
Senator Ramdeen, your time is up.
Thank you, Madam President.
Senator Deonarine.
Thank you, Madam President. Let me first begin by thanking Her Excellency for this tremendous honor of being able to serve my country and its citizenry. I look forward to working with my colleagues as we together seek to realize Trinidad and Tobago's true potential. Madam President, I stand here today to contribute on the truncated version of the Income Tax Amendment Bill that was brought to Parliament almost 6 months ago, and I immediately reflect to the two words in my last sentence, together and potential. How much has the potential of Trinidad and Tobago been stymied by partisan politics, the discontinuity in policy, a lack of transparency and accountability, and white-collar crime? Madam President, today I would like to briefly remind my colleagues and the people of Trinidad and Tobago that the lack of the passage of these bills, and I speak about the 3 bills, the sister bills as well, can create a wave of de-risking and create economic implications for the economic players in Trinidad and Tobago. Without these pieces of legislation, there would be an increase in the propensity for international banks to de-risk respondent banks. Following the 2008 global financial crisis, global banks began this process of de-risking as they began to re-evaluate their risk and business models. As a result, international banks have been reducing activities in areas that they perceive as either profitable or detrimental in to their risk tolerance. The global trend has been most evident in the reduction of correspondent banking relationships and have impacted the Caribbean region, most evidently cases of Belize, Barbados, Bahamas, and St. Lucia. Tightening these rules have proven to have adverse consequences for small, open, developing economies when access to financial services are eroded. Correspondent banking relationships are critical for enabling key financial and economic transactions, and without them, the Trinidad and Tobago economy can suffer as international trade, investment flows, and remittances are reduced. Madam President, what this would mean for our importers and exporters. You see, Madam President, conducting cross-border transactions would now become more difficult and take longer and even cost more. Madam President, this can seriously affect our trade balance and undermine economic activity in an environment where we depend on the OECD market for almost 60% of our exports and 58% of our imports. But how would this undermine economic activity? Once correspondent banking relationships, once correspondent banks decide to de-risk, increase due diligence, and increase transactional costs, there would be an increase in overhead costs for businesses. There will be limited access to capital investment and raw materials. There will be delays in conducting transactions and delays in sending and receiving shipments. As cross-border transactions becomes more difficult, our ease of doing business ranking can fall. Furthermore, the cost of production for local businesses can increase and even crowd out new and thriving small and medium enterprises. In addition, de-risking can also constrain investment flows, as foreign investors will be discouraged to invest in Trinidad and Tobago due to uncertainty attached in repatriating profits back to their home country. Yet another issue that can jeopardize our business climate. The acquisition cost for foreign exchange will further be exacerbated as the foreign exchange availability in the banking sector will reduce. Likewise, our current account balance can face another hit in the immediate short to medium term as our imports become more expensive and exporters adjust to the increased burden of excessive cost and accessibility barriers. As a consequence, our net official reserves, having already declined by 11% in the last year, can further suffer and neutralize the IMF predicted slow in decline. More concerning is the possible increase in activity in the informal cash economy as well as the parallel foreign exchange markets. These metrics feed directly into the sovereign credit rating by Standards & Poor's through institutional assessment and banking industry country risk assessments, among other factors. The current S&P rating is BBB+ with a negative outlook. At this time, the country cannot afford any downward pressure on our sovereign credit rating, negating the work of the Ministry of Finance over the past couple of years. Moving on to remittances, and I wouldn't like to dwell here because the issue of remittances have well been ventilated in the public domain and also in this honorable house. Remittances receipts account for less than 1% of GDP since 2011, but has been maintaining an upward trend until 2016. Furthermore, remittance outflows have been increasing exponentially since 2011. Although this contribution to GDP is small, the resulting socio-economic consequences cannot be considered negligible. In summarizing, Madam President, we need to protect our correspondent banking relations, as their restrictions can impose a negative impact to the economic development of this country. It can increase financial inclusion, reduce trade flows, hamper foreign direct investment inflows, reduce remittance flows, contribute to the growth of the informal financial sector, exacerbate the perception that the country is high risk due to financial crime. It can also increase the cost of production that can ultimately be transferred to the people in the form of higher prices. And the list goes on and on, Madam President, all of which can compromise the country's business climate, private sector development, global competitiveness, and overall economic progress. According to our Vision 2030 strategic agenda, the private sector is expected to lead the diversification thrust of our country. Vision 2030 sees the government playing a facilitative role towards towards development in terms of creating an enabling environment. To do this, we all need to place emphasis on removing constraints and creating incentives that can mobilize the private sector, not adding to them. This bill may not meet the Global Forum requirements, but in a couple of months, this Honorable House will once again have to deal with this matter. I beg to question, are we upholding our responsibility to the citizenry of Trinidad and Tobago? I respectfully ask, Madam President, are we working towards achieving Trinidad and Tobago's full potential? Is our country's economic and social stability our utmost priority? As I end my brief contribution today, I would quote our national motto: together we aspire, together we achieve. Thank you, Madam President.
Honourable Senators, permit me to congratulate Senator Deonarine on her maiden contribution. Senator Richards.
Thank you very much, Madam President, for recognizing me and allowing me to make what will be a brief interjection. Yes, I know I always say that and go on for quite a while, but it will be brief today. And before I actually go into the presentation, let me also join you in congratulating Senator Deonarine for her maiden presentation, which was extremely sober, and one can tell her experience and expertise is going to be well utilized in this Honourable House. She was telling me before she went on that she was so nervous. You did very much better than I did, so congratulations to you. Madam President, this is a very critical piece of document, this Income Tax Amendment Bill 2018. And I echo Senator Obika's sentiments in terms of his brief interjection with the Attorney General. Although it's just 5 clauses, it is extremely important, as articulated by the Honourable AG, because of what it means for Trinidad and Tobago moving forward. Whether or not it meets Global Forum benchmarks to move us out of grey and into more of a compliant mode is left to be seen, given the amendments that seem to have had to be made. From what I've heard and read, it may not, but certainly it will go some way in showing the authorities that we are trying in some ways. And it's better than not trying and letting it fall down, because I think there will be no doubt left in their minds at that stage that, well, this country is very recalcitrant in that regard. So I think that needs to be mentioned. One of the things I want to cite, the aspects I want to cite through you, Madam President, let me turn this way before I get into trouble, is the unfortunate continuation of an extremely acrimonious engagement between key stakeholders in terms of the people required to collaborate on these types of legislation, and all, quite frankly. And I echo, I think I've said it in the past, I echo Senator Deonarine's final comments that the only way we're going to move forward is together we aspire, together we achieve. I am not naive to the nuances of party politics, but at some point we need to put down the gauntlet and realize that the differences are less than the commonalities in terms of our aspirations for Trinidad and Tobago. And in these sorts of situations, we really need to look at that. Another one of the issues I have in terms of this process, Madam President, is again, like I cited in the Petrotrin issue, the type of approach taken, and I'm going to put this one on the government, because the government is running the country, in the information outflow to the general public. Because like with Petrotrin, there's a deficiency in an effective communication strategy related to these bills, not only for stakeholders like us, but for the general public to have a clear understanding, because there's so much noise in the ether that very often the public is confused as to what the real issues are, what the timelines are. One of the interesting bits of information I've been able to get, and this comes from the Global Forum on Transparency and Exchange on Information for Tax Purposes, a roadmap for developing countries document, which is a report of the G20, which is dated the 5th of August 2014, is steps to effective implementation of these processes, particularly, or these bills or the amendments that are required to meet the global standard benchmarks, like FATCA. And they're just 4 simple steps, but they have huge implications. One, an understanding of what's at stake. And the AG has outlined through you, Madam President, that this is 8 years in the going. And I would imagine that in 8 years, the public should have had a more clear understanding, one, from the previous government, and secondly, from the present government, on what is at stake or what was coming down the pipeline. So the public has a clearer understanding of what's happening to make decisions as to whether the government is advocating adequately or the opposition is making a clearer point. And that, to me, is again lacking. And so the understanding of stakeholders and the publics, and this is very important too. Consultation, and this is the G20 which provided this report. Consultation, effective consultation. And you know, consultation seems to be a nebulous word in Trinidad and Tobago. Consultation can mean 3 people in a room somewhere with some information given without real collaboration. And that is lacking. 4, legislation and international agreements, which we are seeking to amend here to meet the benchmarks. And 5, implementation and IT training. I just want to quote, by your leave, Madam President, a part of the document, and this particular clause has to do with, and these are 4 real areas: corruption, tax evasion, terrorist financing, and money laundering. One of the areas is tax evasion and offshore wealth. And to underscore the importance of this, and I will say from the very start, I'm not happy with all aspects of this, and I'll point out 2 particular areas that I'm extremely concerned about, but I would say it will be irresponsible of me not to support it given the timelines involved. So I have to support it in this instance, not that I'm happy with all aspects of it, because the alternative could be too damning for Trinidad and Tobago. I think we have a wider responsibility. For those of you old enough to remember Star Trek, and Senator Ramdeen said it, when he says the importance of proportionality and this, and abrogating rights of one person for the larger population. Spock used to say the needs of the many outweigh the needs of the one. For those of you who remember Star Trek, and I think in this case, when it comes to terrorism and national security issues, that is applicable. And in this case, the needs of the one will mean very little if the needs of the many are thwarted by terrorist activity, etc. So we have to come together on this. So I will quote, detection of tax evasion is critical for developing countries. In particular, US $8.5 trillion of household assets are held abroad. In 2012, more than 25% of all Latin America and almost 33% of all Middle Eastern and African households' wealth are held abroad, compared with the worldwide average of 6%. So estimates of tax revenue and illicit financing flows lost by developing countries generally range in the hundreds of billions of US dollars per year. So we see the shortcomings of legislation that doesn't meet the benchmarks in this case. Also, Madam President, another interesting aspect of this that I would like to cite is to underscore what Senator Ramdeen indicated in terms of us jumping to the beat of international agencies, and we have to, we're a small country, but we are seeking here to grant automatic access to tax information. And we have $22 billion of suspicious transactions cited by the FIU. We're not using the same information effectively in our own jurisdiction, but we're granting access internationally. What does that say about us in the wider scheme of things? The mechanisms have to be tightened so that we can benefit from the same information that we're granting access to international agencies, and we have to look at that. Another aspect of this, through you, Madam President, is the issue of, and I know it's before a joint select committee, but if we're looking at the issue of corruption, tax evasion, terrorist financing, and money laundering, the issue of the importance of finally passing gambling and gaming legislation, effective gambling and gaming legislation in Trinidad and Tobago, because it's directly tied to this, because a significant percentage of the monies that pass through an unregulated gambling and gaming industry goes toward terrorist financing. So that has to be one of the complementary bits of legislation that strengthens this if it is to be effective. Another part of the document that I think is noteworthy of mentioning, Madam President, is the cost consideration in implementing the standards. So passing the legislation is one thing, even if the legislation meets the international benchmark for global forum. But then there are some government cost factors and financial institution cost factors involved. And these include the existence of legal mechanisms for international exchange information, one. Some of these are provided in the extended bill. The existence of legal mechanisms to access and exchange information held by financial institutions and other relevant institutions. The degree of skilled personnel in tax administration. Is that applicable for Trinidad and Tobago even if it's passed? The current use of information technology in tax administration. That's also one of the underlying foundational mechanisms that is necessary for this to be effective. The existence of accuracy, or the existence and accuracy of electronic domestic taxpayer database to enable a high degree of matching data. And I know the government has been advocating for the Revenue Authority, which should provide the framework for this, but that's not yet here. The scope of partner jurisdictions with which standards will be conducted. The current confidentiality and data protection measures, legal, information technology, and human resources. That is a big question mark in Trinidad and Tobago. The amount of information to be received and not received, depending on the legislation. And also in terms of the financial institution cost factors, and these are not only, as we realize, financial cost, but social cost also. The connection with multinational groups allowing replication of existing systems in branches, subsidiaries, and developing countries. The extent to which customer records are already maintained in electronic form and protected. The extent to which customer records are centralized or fragmented within various financial institutions in a particular jurisdiction. The degree of sophistication of existing customer due diligence is the wider population, as I said with the education faculty before, understanding what is required of them as we move forward, because they are the real ones that will have to be affected by this. The existence of information communication processes for domestic reporting to the tax administration. As I said before, the government is touting the Revenue Authority as the mechanism through which that could be achieved. But these are fundamental requirements, according to this G20 document, that need to be in place, even if the amendments here meet the benchmark. The scope of reportable accounts within the jurisdiction and the current confidentiality and data protection measures, legal, information technology, and human resources. And that's for financial institutions. Another one of the points I want to raise, Madam President, and I, through you, discovered this through research, is a concern from CARICOM countries. And this is not something that is new to smaller developing countries. And the disparity, or the disparity in requirements between the larger countries, literally forcing smaller developing nations to comply when the playing field is not equal. And the suggestion by many experts in this field that CARICOM, or the region, should have petitioned as a group to G20, as opposed to individual nation states being asked to supply information and different legislative agendas and amendments, simply because different smaller developing states have different legislative framework statuses. They have different capabilities in terms of resources. They have different response rates because of their limitations on resources. And when we are not able to, as a grouping, and it's interesting that we have had a CMSE conference in Trinidad and Tobago this week, we're not seeing that we cannot, it is not as productive for us to fight these battles alone, because we will always be at a disadvantage to the G8 countries and the other big groupings, the European Union, etc., because of the mere size that we are. And we must understand that that is really the way forward where these types of legislation are concerned. The CARICOM grouping of attorneys general must come together and discuss these things beforehand so that we can present and petition together. That is the only way we will be able to get parity in terms of what is being requested of us, because as it is now, we're really not being given much choice in the matter. And I'm sure that the larger countries have a lot more, like China and Russia, have a lot more leverage simply because of the size of their economies. And the only way for us to be able to even in a small scale, balance those issues is to come together as a CARICOM region. Madam President, to go specifically to the bill now, and the issue I have is similar to what was outlined by Senator Ramdeen with this section 6B and 4, and that wide-ranging in terms of interpretation involving fraud and dishonesty. And I just did a quick scan, and I know I'm not a legally trained mind, of the meaning of, well, fraud is fraud, but dishonesty. And the number of interpretations one can have for dishonesty. If you lie to your wife, you're dishonest. If you lie to your husband, you're dishonest. And when these clauses and phrases end up in law in other jurisdictions, there are checks and balance to protect you under these conditions that do not necessarily exist in smaller states like Trinidad and Tobago. We are now, as we see, we have a new commissioner of police, but that will not in an overnight time frame weed out corrupt police officers who are apt or want to misuse the law when it's in these kinds of vague states. And that is the concern, because when we, as the Honorable AG indicated, try to balance the proportionality of it, it must be against the backdrop of an institution that people can trust. Because at the end of the day, this is a police officer, and yes, we should be able to trust the police, but in reality, the population does not. And we know there are elements within the TT police service that will abuse this. I have no doubt about that. And that is of great concern, and I understand the need to document it in a particular way, but it must be against the backdrop of understanding where we are and where we are not in terms of these institutions, because this same thing may come back to, as the old saying goes, bite somebody else who it was not originally intended to bite. So, you know, in closing, Madam President, because I did say I would be short, you know, the AG quoted the Honorable Prime Minister Barbados Mia Motley in her visit to Trinidad and Tobago, claim the ground on which you stand. But I want to say, let me go further to Jamaica. And if we are going to be demanding more of citizens in terms of the abrogation of their rights, we need to be able to use information to deal with corrupt elements, white-collar crime, corruption, tax evasion, terrorist financing. As the old Jamaican saying goes, dance a yard, dance at home before you dance abroad. It makes no sense making information available internationally if we can't use it here. And the institutions are not looking like they're going to be able to use it here. We had to have a North American law enforcement agency tell us we have cocaine in our backyard, shipping from Trinidad and Tobago many years ago. Nothing has come out of that. Is this law going to end up being the same thing? We're giving information or granting access to information to international agencies, information that we have right here that we are not using to protect the very citizens who the law is touted to protect and the state of Trinidad and Tobago. So I would just want us, Honorable AG, to, while we are doing this, and it's a saying you like to use, let the plane take off and build it. But I ain't seen you on the carriage fixing at all. And the carriage, well, your wings out and thing, excuse me, you know. But there are some fundamental elements that can cushion our landing in these instances that are not being championed in a parallel manner. And with those few words, Madam President, I thank you.
Nance.
Thank you, Madam President. Madam President, might I, on behalf of this bench, also extend my congratulations to Senator Deonarine for her concise, clear, and very lucid presentation, truly representative of an independent bench. So I thank you. Madam President, Senator Ramdeen, in his commentary, said something to the effect about Trinidad and Tobago being a democracy and not accountable to Global Forum, which, of course, we all clearly agree with. But what Senator Ramdeen failed to comment on was the fact that the reason why we have a responsibility to Global Forum is because his government, when they were in power, created a commitment for Trinidad and Tobago with a deadline. We cannot ignore that, Madam President. When the Global Forum came up with the plan to deal with the issue of transparency of information, they imposed obligations on the G20, which were immediate. But with respect to developing countries, they had options as to when they would sign on and when they would accept these obligations. Trinidad and Tobago had that option as well, and Trinidad and Tobago signed on, which made us responsible for doing certain actions by this time. And during the period 2011, when the obligation was created, to 2015, when the UNC demitted government, they did nothing to satisfy the obligations that they themselves took responsibility for, and they have squarely placed us in the position where we are today. Among the countries that signed on for this obligation to act by 2018, from the Caribbean, Antigua and Barbuda, Aruba, the Bahamas, Belize, Curacao, Dominica, Grenada, St. Kitts, Nevis, St. Lucia, St. Vincent and the Grenadines, St. Martin, and of course Trinidad and Tobago. The countries that deferred giving a commitment to the Global Forum as to when they would satisfy these international obligations include Dominican Republic, Jamaica, and Guyana. So an option existed in 2011 as to whether we would accept an obligation to comply with this deadline that this government is now seeking to meet. And the government at the time accepted the obligation, did nothing, left it up to us, and now are asking us, why are we accountable to Global Forum? Because the country made a commitment to Global Forum. That is why we are accountable. So, Madam President, while I acknowledge that we do have a responsibility, and the Attorney General, as the government's representative, ensuring that we uphold our international obligations, his focus is on satisfying Global Forum. As a tax person myself, my focus is other than that, and it is more in line with Senator Richard's focus, which is how can the change in the laws that we are seeking to introduce benefit Trinidad and Tobago? So let's look at what Global Forum said. This is an OECD article printed in November 2017. Global Forum's plan of action for developing countries' participation in the automatic exchange of information protocol. And what the OECD said was Global Forum seeks to counter tax evasion and avoidance by increasing global tax transparency, international cooperation, and transparency of corporate bodies, arrangements, and financial information. Although all jurisdictions suffer from tax-related abuse, this problem is often particularly acute in developing countries, and I would add developing countries like Trinidad and Tobago. The report goes on to say developing countries are disproportionately exposed to the risk of international tax evasion and avoidance, and therefore their need for access to the world's information exchange systems is proportionately greater. By not participating in the automatic exchange of information, developing countries risk losing out in their fight against abusive tax practices. Conversely, by being part of the global move towards greater tax transparency, they stand to gain the most by generating additional tax revenues, which are of critical importance for delivering the most fundamental public services and fighting poverty. So this is a report of the Global Forum. So while there seems to be a focus that we need to be able to supply information to the rest of the world, and in particular the more developed countries, so that they can improve their fight against tax evasion. This Global Forum initiative really should help Trinidad and Tobago and other developing countries in their quest to make their tax systems more efficient and to make their crime-fighting apparatus more effective. And that is the focus that I think we need to ensure that we do not forget. It is not all about satisfying the Big 20 and ignoring our own needs and obligations. So, what will getting involved in this and satisfying our obligations under this protocol allow us to do? Yes, we will be required to provide information to external countries in respect of their citizens earning income here. But the converse of that, and to me the more important aspect of it, is that we will be entitled to receive information from foreign tax authorities in respect of information earned, one, by our nationals who earn income abroad, and two, in respect of foreign companies carrying on activity in Trinidad and Tobago. While the reach of the IRS in the US and the UK tax authority may be broad, and they may independently have some chance of securing information internationally on their citizens and on entities carrying on business in those countries, Trinidad and Tobago does not have that broad reach. We need the assistance of these foreign tax authorities if we are to have any hope at all of ensuring that the people who operate and earn income within our shores account for the correct amount of tax that they should in their income. As the AG would have pointed out in his delivery, we engaged foreign consultants, and they have indicated to us that the participants in the biggest sector in the economy, the energy sector, has been understating their income in Trinidad and Tobago to the tune of $6 billion a year. This is something that Trinidad and Tobago could do with. If we had access to information from other tax authorities, we may have been in a better position to access that kind of information earlier, so we could have taken effective steps to deal with it. Now we have Trinidad and Tobago with our tax administration, which we admit is not as efficient as it should be, which we are seeking to correct. And as Senator Richards indicated, we are hoping to bring Revenue Authority legislation before the House shortly. But let me give you examples of what this inland revenue is currently facing in terms of having to battle to try to ensure the collection of taxes. There are various forms of ways that people can avoid paying the correct amount of tax. They can change their place of residence, for example, because Trinidad and Tobago requires an individual to account for tax on his worldwide income if he's resident, domicile, and ordinary resident in Trinidad. So if you change your place of residence, you immediately remove that. So a company, for example, if it is incorporated in Trinidad, if its management is in Trinidad, it will be taxable in Trinidad. So what companies do is they move their management to St. Lucia, offshore, where the tax is maximum 1%. So they're no longer resident in Trinidad and therefore no longer liable for tax in Trinidad, but all their income is earned here. That is one way that we lose millions and billions of dollars. We have other ways that we lose it is tax havens. That is something that is very popular. We have offshore companies springing up all over. they're not only established by Trinidad companies, but more importantly, from our perspective, is we have foreign companies earning income in Trinidad, registering in offshore companies, which allows them to avoid paying withholding tax on dividends that they remit abroad. Another significant source of loss of income in Trinidad and Tobago. So we have tax shelters, we have tax planning options, we have financing options, a whole range of issues that require not only continuing knowledge and development of the local tax authority, but it requires you to secure information on what these entities are doing and what they're earning outside of Trinidad and Tobago. Transfer pricing, or what they call transfer mispricing, is a huge issue. So they will say to us that this is what we have paid for, or this is what we have earned from the sale of oil and gas or cement or whatever it is we're selling. But when we look at the international market, what they do is that they take the gas that is produced here and sell it to a related party for $3. And then that related party that is located in a tax haven like the Bahamas, for example, where they don't have a tax, or Cayman Islands, where they don't have a tax system, will then on-sell that gas to China for $10. So that's $7, which should have been earned in Trinidad and Tobago, is recorded in the Cayman Islands, which has not really contributed to any value to that transaction, but records all the income. Trinidad loses out on that. The Cayman Islands gets all the income. I'm sorry, all the income is reflected in the Cayman Islands, no taxes paid, and therefore the company significantly gains in Trinidad and Tobago significantly loses. When that company, however, reports its overall income to the United States, if that's where they're located, and the United States has an exchange of information agreement with Trinidad, we are able to see what has been recorded here versus what is reported there, and we then have some hope of identifying the transfer pricing issues and being able to say, well, no, because the benefit of this transaction all arose in Trinidad, Trinidad should get more of that income. Without that exchange of information agreement, there's little or no hope that we will ever be able to identify that discrepancy. And therefore, little hope that we will ever be able to earn a proper rate of tax on the economic return enjoyed by these companies. And this is what, in my view, proper legislation allowing for automatic exchange of information will bring to Trinidad and Tobago. So let us not only focus on, we have an obligation, we have to send this information. It is how will this help us, and it will help us significantly. We have countries like the United States and the UK that are significant powerhouses in the tax world. The IRS is known and feared throughout the world, but they are facing challenges with respect to their compliance. If you look at the list of companies that have been recognized globally in terms of avoiding, because evasion is illegal, I'm not going to accuse them of evasion, but they avoid certainly billions of dollars in taxes because they arrange their affairs in this global market, in this global world, to minimize the liability that they will pay. We are talking about companies like Google, Amazon, Starbucks, Apple. All powerhouses in the international scene. We've all heard about each of them. We may all have contributed to the income earned by each of them. These people, exactly, these people are known globally for understating their income. In a report issued by Wikipedia in December 4, 2018, it was reported that 25% of the companies listed on the Financial Times Stock Exchange avoided tax by locating their subsidiaries in tax havens. When the United States did a review of the definition of tax havens in that context, it increased the number of people evading by 98%. Because some of you may be surprised to know that in certain contexts, Trinidad and Tobago may be regarded as a tax haven because we have free zone legislation, which I will deal with a little later. So companies like this, operating in the jurisdictions of the United States and the United Kingdom, which have robust tax systems, avoid tax. What hope does Trinidad and Tobago have of ensuring compliance by the players in our market if we do not have the assistance of the international world through the exchange of information? I'm reading an extract from The Guardian, not Trinidad Guardian, this is the UK, Tuesday, the 30th of August, 2016, where they reported that Apple was ordered to pay 13 billion euros to the Netherlands. No, to Ireland, I'm sorry, because it entered into a transaction with Ireland to locate the headquarters of Apple there and arranged with them to pay taxes, the effective tax rate of Apple. Imagine the kind of money that Apple is making. Pay tax on the income recorded in Ireland at the rate of 0.005%. It took them years to bring Apple to account, and there's still a debate between the European Union and Ireland as to whether the European Union should make Ireland accept more taxes from Apple, because they entered into a transaction with Ireland. But they did that, they were able to do that because the European Union shared information on Apple's activity within Europe. And therefore, they were able to ascertain the quantum of income earned and the quantum of tax that should reasonably have been paid by Apple. That was brought to account, and they were able to sort it out. So that shows you the effectiveness and the importance of being able to share information among jurisdictions. You will recognize that the world has gone global. Companies are not restrained to any one jurisdiction. They operate globally. In order to properly combat the transactions, the structures, the avoidance that is promoted by these companies, we also need, as collectors of revenue on behalf of government, to have a global reach. Without access to these tax information agreements, we will not be able to do that. We will not be able to make any dent in the fight against tax avoidance by these international companies. So it is my view that apart from our international obligations, we need to consider the passage of the legislation that is before you, and that will still come before you, for the benefit of Trinidad and Tobago. Because we need, as Umbala used to say, we need the money. And so we need to ensure that we put things in place. Max and House, I'm sorry. Max and House, we need the money, and we need to ensure that we put things in place to allow us to get that money. So Senator Ramdeen also said that we pass the legislation, but nobody is being prosecuted. Where will we be? If we pass the legislation, nobody is being prosecuted. Where will we be? But if we have no legislation on which we can prosecute people, where will we be? So what we are saying is, give us the opportunity to be able to get in the fight. The police are asking us for this legislation because they have information they need to confirm, they need to strengthen, they need to support, so they can bring the white-collar cases that we have all been clamoring for. The FIU is asking for this legislation because they also have information that only takes them so far. They were successful, as the Attorney General indicated to us, in preventing $13 billion in suspicious transactions, but we have billions more that we have to stop. The government is spending millions and millions of dollars every year supporting individual units within its structure that cannot talk to each other. And that makes all of them ineffective. We have to allow them to talk to each other so they can share the information, so they can become effective and give us a real chance of fighting financial crime, which we have to do. As the Attorney General says, crime is sponsored by
Minister. Honourable Senators, we will now suspend for half an hour and return at 5 p.m.